Today's Thursday, February 3rd, and court will be starting shortly.
Are we ready?
All right, ladies and gentlemen, good morning, and court will be in session. And for your information, everyone else's information, the defense has rested their case. The court's heard motions, and we're now ready to proceed with rebuttal.
Your Honor, the state would call Gary Gitchell. Yes. I observed him in the courtroom during some of Dr. Alshay's testimony. I don't know about him being here prior to that, but he is a rebuttal witness. He had been released from the rule by the court and by agreement with both parties, and therefore I'm going to allow him to testify. For the record, you are Inspector Gitchell, who's previously testified in this case?
Yes, sir, I am.
Inspector Gitchell, I believe that you were in the courtroom yesterday during some of Mr. Alshay's testimony. Is that correct?
Yes, sir.
Mr. Alshay testified that the fact that this incident happened at night was not mentioned until page 18 when Detective Ridge said, "The night you were in these woods." Was the fact that this happened at night mentioned prior to page 18 of the transcript?
Yes, sir. Mr. Alshay's remark was incorrect, in so much as on page 12 of the transcript, Jessie states, "Well, after all this stuff happened that night." That's the first time that night is mentioned by Jessie himself.
All right. Had you or Detective Ridge mentioned night prior to that?
No, sir.
Mr. Alshay also testified in regard to the follow-up tape that nowhere in the record does Jessie say 7 or 8 until you mentioned 7 or 8. Where did you get 7 or 8?
I derived that from, there again, back on page 12 of the transcript. Jessie states, "Then they called me at 9 o'clock that night."
All right.
And then you refer to page 24 of that same transcript. And then there's a mention of how long after you got home you received the phone call, and Jessie responds an hour.
Okay.
So that's where I deducted the time frame.
Okay. Now, if you would refer to page 3 of the transcript, where the transcript shows that Detective Ridge said 9 o'clock in the morning, Mr. Alshay testified that Jessie said that, not Detective Ridge, and that the transcript was wrong. Who said that?
Detective Ridge is the person that said 9 o'clock in the morning.
Right.
And I even have the tape which shows that Detective Ridge said that.
All right, would you play that portion of the tape again?
Then I went with them.
All right, when?
Wednesday,
All right, when did you go with them?
that morning.
At 9 o'clock in the morning?
Yes, it is.
All right, and who just said 9 o'clock in the morning?
That's Detective Ridge that said that.
All right. If you would, Inspector Gitchell, describe for the jury the room that this interview took place in.
The room which we used to interview Jessie in was Detective Lieutenant Hester. She's a female police officer at the police department. Her room is probably the nicest room that we have in the detective division. She has pictures of her children, colorings that they've done at school, saying, "Mother, I love you," things of that nature. So it's probably the most relaxed atmosphere that we have in the police department.
All right. And describe for the jury the atmosphere during the interviews themselves, both on tape and off tape.
Well, during that time, we were probably nervous, but the atmosphere itself was a very laid-back and subdued nature.
During either interview, on tape, off, first interview, follow-up interview, was any pressure or intimidation used by either yourself or Detective Ridge?
No, sir, none whatsoever. We knew this case, due to the type of coverage it had received, that whomever would be picked up, we would have to talk with this person and use the utmost care and treat them truly with kid gloves, as if we were talking with one of our own children.
And was there anything in either of the tape recorded portions that indicate anything on the defendant's part that you observed or heard that would indicate a lack of pressure or intimidation?
Yes, sir. On the second tape that I did with Jessie Misskelley, there are 3 places in there which he's yawning. And,
He's yawning?
Yes, sir. You can hear him going, just yawning. So it's not any pressure there.
All right, and you can hear this on the tape?
Yes, sir, you can.
Did you or Detective Ridge ever feed any information to the defendant?
No, sir.
Did you or Detective Ridge? Okay. What, if any, manipulation did you or Detective Ridge do to the defendant?
None whatsoever.
Would you ever try to get a person to confess to a crime that they did not commit?
Absolutely not.
I don't have any further questions.
We have a moment, please. Yes,
John, I do have one more question. In regard to State's Exhibit 105, that's the, excuse me, I think that's the photograph, or the series of photographs that were shown to the defendant.
Yes, sir.
When the defendant identified which boy had been sexually mutilated, did you or Detective Ridge use any suggestion to suggest who he should pick?
No, sir, not whatsoever. He picked out this young man right here, the Byers boy.
Okay.
He mentions Michael Moore simply because in the caption, Michael Moore comes underneath this picture. And that's why Detective Ridge read the caption underneath to straighten that out.
Okay.
He did pick the right boy who was castrated.
All right. When he identified, as far as when when he identified who was castrated, where was the picture?
The picture was sitting on the desk.
All right. Was it laying on the desk?
Yes, sir.
All right. And was anybody pointing to any of the pictures?
No, sir, not at all.
Okay. I don't have any further questions.
Inspector Gitchell, this statement wasn't videotaped, was it?
No, sir, it wasn't.
And you didn't take notes during the first statement, did you?
No, sir.
And since you didn't take notes prior to the tape recorder coming on, we really don't know exactly what questions were asked and what questions were answered, do we?
Just from recollection.
But if we had a videotape, we would know for sure, wouldn't we?
Yes, sir.
Now, at an earlier hearing on January 13th in Marion, I asked you about going on the second tape, and immediately you're telling Jessie, you told me earlier it was 7 or 8.
Yes, sir.
And I asked you, when did you talk to him about that, and your response was you didn't remember.
My first response, if you'll look in the transcript, was I believe it was during the very first taping. Is that not correct, counsel?
That's the only copy that I have.
Well, I've got a copy, but what page is it? Inspector Gitchell, what page is that on?
146 is what page was shown me.
That's toward the very end.
I believe your response, Detective Gitchell, was that you weren't sure.
I did make that response later, but my first response was I believe it was during the first tape. And then subsequently, after several more questions from you, I told you I really wasn't sure. But I first do recall making the statement, I believe it was during the first tape. Was that not correct?
I believe that's correct. You just said you weren't sure. You thought it was the first tape.
I thought it was the first tape.
And now you're more certain of that.
It was during the first tape, yes, sir.
Pass the witness.
How did that come up in that other hearing about what was the whole?
It was in the same gist as now, about the mentioning of the times. Mr. Stidham asked me if, at what time did that statement come up? I stated at first I thought it was during the taped interview, which this is what the transcript is of, which I just testified to.
Were you given an opportunity, did you go through and look through every page of the transcript during that hearing to see if you could find where it was?
No, sir, I have not had an opportunity to do that.
All right. Is that until after the hearing?
Right. On this, that I've looked through it, yes, sir.
All right. In fact, referring to page 136 of that hearing, Mr. Stidham asked you, why does the tape we just heard, the second tape, say you told me earlier this happened about 7, and what was your answer?
My answer to him was you didn't hear all of the first tape. You've got transcripts of it, and if he had played the whole tape, you would have heard what I was referring to.
Okay. I don't have any further questions.
In the second tape statement, you don't even know what time that was, do you?
It was approximately 5 o'clock.
Why didn't you announce what time it was on the tape?
I didn't think to do that.
And there's several gaps in the tape, is there not?
Yes, sir, that's accounted for from me leaving the room and going back and talking with Mr. Fogleman, because he had some questions for me to ask Jessie.
The prosecutor was sending you back in the room to ask Jessie more questions.
That's correct.
Isn't it customary, Inspector Gitchell, to when you get on the tape to announce what date it is, what time it is?
That would be customary.
Let me finish my question, please.
Well, I was going to answer the first part.
Isn't it customary that when you stop the tape, you announce what time it is, and if you go back on tape, you announce what time you begin again?
That's customary in this type of statement, which we did do that. However, this only reason I did this tape is to verify, because I was sure nobody would believe what I would be saying. So that's why I carried the tape in with me.
Nothing further.
I don't have any further questions.
Let you may stand out. You're excused.
Okay.
Call your next witness.
Final statement from Dr. Vaughan Rickert.
Doctor, you were previously sworn. Yes.
Would you state your name, please, sir?
Vaughan I. Rickert.
And Mr. Rickert, where are you employed?
I'm employed by the Department of Pediatrics at the University of Arkansas for Medical Sciences and also affiliated staff with Arkansas Children's Hospital.
Okay. And in what capacity are you employed there?
I'm employed as a clinical psychologist, more known as the pediatric and adolescent psychologist and associate professor of pediatrics.
Okay. And could you explain to us briefly what you do in that job as a pediatric and adolescent psychologist with the Arkansas Children's Hospital?
My role is threefold. My first role is providing clinical service where I diagnose and treat children and adolescents who may have diagnosable or substantial psychological difficulties in terms of both evaluation and treatment. My second role is to do and conduct research. My research interests are in adolescent medicine issues, particularly revolving around adolescent substance use and various health-related behaviors that adolescents might engage in, which could compromise their health in the future. My third role is the teaching to provide education to pediatric residents and medical students surrounding child and adolescent development and treatment and diagnosis issues that may help them in their practice of pediatrics.
Now, when you refer to adolescents, just so we understand, what age group are we talking about?
Adolescence generally refers to individuals between the ages of 12 to 21.
Okay. Now, could you briefly tell us about your background, education, training, and experience in this particular field?
Yes, I received my bachelor's degree in psychology from Michigan State University in 1977. I went to graduate school to get a master's and specialist degree in school psychology. School psychology is the subspecialty of psychology looking at psychological processes and difficulties that children experience within a school setting. After working professionally for 3 years in that field, I went back to get my doctoral degree in professional psychology and specializing in clinical psychology. As a part of the degree requirements, you were required to do a full-time internship, which I did at Johns Hopkins University School of Medicine in Baltimore. After completing that internship, I graduated and was awarded the degree and was employed at the University of Arkansas for Medical Sciences in 1986. Most recently, I have been awarded fellow status in the Society of Adolescent Medicine, which is a elected title to indicate substantial contributions in the area of adolescent health and medicine.
Okay. And is that an award that you receive or an honor that you receive that's based on your scientific achievement?
Yes, it's directly related to my scientific contributions to the field as well as my educational efforts within the society.
Okay. Now, could you tell us kind of what a general difference between psychology and sociology is?
Generally, the fields, while related, focus on differences. In psychology, you are typically taught and evaluate children, particularly in the clinical areas, looking at mind-body relationships, more particularly psychological processes, psychic processes, and things of that nature. But it's definitely looking at the individual person, child, or adult. Sociology, while they may be concerned with individual behaviors, is more recognized looking at groups of people. So within both fields there is some overlap, but within the areas of clinical psychology particularly, you are trained to treat and diagnose individuals, which is not something that sociologists would be trained to do.
Now, as part of your job with the Children's Hospital, do you review evaluations performed by other doctors to determine the significance of those evaluations and also what further things might be done in regard to a particular patient?
Yes, that's part of my standard procedures.
Okay. And in doing those evaluations, are you familiar with some of the tests that were referred to by Dr. Wilkins during his testimony?
Yes, I am.
Okay. Your Honor, at this time we would submit Dr. Rickert as an expert in the field of adolescent psychology.
You want to take him further? No. All right, you may proceed.
Now, Dr. Rickert, what have you examined or looked at prior to coming here to testify today?
I have reviewed Dr. Wilkins' psychological report, and also I have reviewed in the past transcripts that he was testifying to in November and December, I believe.
Okay. And those were hearings in this matter, previous hearings in this matter?
Yes, they were.
Okay. And were you also present for the majority of Dr. Wilkins' testimony yesterday?
Yes, I was.
Okay.
Yes. No. You tell me that. No.
I'm not going into that.
I just want to make sure. Thank you, Ron.
Just to clarify something, Dr. Rickert, when you said that you had reviewed the evaluation, it's Dr. Wilkins' evaluation of this defendant, correct?
Yes, that is correct.
Okay. Now, let me ask you, have you ever done any work as a professional witness before?
No, I have not.
How much income did you receive last year as a professional witness?
I received $0.
Okay. And have you received or have you been promised anything to come testify here today?
I have not been promised anything.
Now, first off, let me ask you, are the tests, the standardized tests that Dr. Wilkins referred to in his report, are they based on scientific method?
Some of them are.
Okay. Can you explain for us what scientific method means and why it's important?
When looking at a way a person responds or the score that one gets on a particular instrument, we want to make sure that that score would happen again and again and again, or that the test is reliable. What you get the first time is likely what you would get the second or third time. In addition, you also want to make sure that the test is valid. That is, what it says it's supposed to measure is in fact what it measures. Obviously, in the field of psychology and in mental health, some of the things that we discuss and try to make attributions to are very complicated and are not very simple. As a result, tests which are standardized and normed provide very useful information because as a part of the scientific method, these tests have been given to a large number of individuals from various different parts of the country at various ages. So that a person who is 13, you are comparing to other people within that sample who are also 13 to look at the way in which they responded to get some index of the difference from normal versus abnormal, high or versus low. In contrast, there are some instruments which don't have this amount of information, and so you're generally limited to the kinds of inferences that you can draw, because we are unsure, or it has yet to be demonstrated, that the results you got today is the same results you would get next week or next year.
Is that why it's important in all fields of science or study that tests be based on proper scientific method?
In order to draw accurate conclusions, that is definitely important.
Okay. Now, you listened to the testimony of Dr. Offshay,
yes,
or Mr. Offshay yesterday. did you hear anything that he testified to that related to or indicated there was any scientific method from which he drew his opinion?
No, I did not hear any such evidence.
I don't know of any. This witness is not an expert in the same field as Dr. Offset is. And now he's going to go up here and say things about Dr. Offset, not the scientific methods not being there. He doesn't know anything about that.
Your Honor, I think he will, and I can clarify this.
All right.
No matter what field you work in, scientific method in order to determine the accuracy of your results is the same whether it's in biological science or whether it's in psychology, correct?
That's correct.
Your Honor, again, my objection is this witness is not qualified to challenge something outside his field. He shouldn't be allowed to testify about things he has no knowledge of. This is the same witness that was on the stand yesterday saying that he had never heard of the Johnson scale of suggestibility. And again, I would submit the
Your Honor,
about that area.
excuse me, but if he's gonna give a dissertation to the jury, then we're gonna need to go back to chambers. If he's gonna make an objection, then I can respond.
I've just made my objection, Your Honor.
All right. Respond.
Your Honor, my response is that he has testified that the scientific method upon which any theory, the reliability of any theory is based, is the same no matter what field it's in.
I asked him to describe what we mean when we say scientific method. All right, now I'm going to overrule your objection temporarily.
Doctor, what is scientific method, or can you describe that for us as simple as possible?
Basically, what you're looking at is the reliability and the validity, or the accuracy of getting the same results time over time, and being reported the validity, that is the truthfulness of a response or a particular result. In the case of biology, making sure that when you treat someone with an antibiotic, that in fact that they get better. And if you would do that over and over again, you would get the same results. Generally, that's accepted scientific method.
And is...
Your Honor, again, my objection is this witness doesn't know anything about what Dr. Offset was testifying about yesterday. He stated, this is the same guy that was on the stand yesterday, I do believe, and he said he'd never heard of the suggestibility scale by Dr. Gitchell.
That's because it's not scientifically recognized.
No,
Okay, y'all have editorialized enough now. I think I got the picture. All right, Doctor, based upon your education, training, and experience, do you have an opinion as to the scientific reliability of what we call that?
Johnson's suggestibility scale.
Well, Your Honor, that wasn't the question that was asked. The question that was asked is whether during the Mr. Offshay's testimony, can you treat a broken arm or your mind?
Is this gentleman?
All right, I'm not going to put up with that. We've been here too long for that kind of stuff now. If you state your objection.
Your Honor, may I vote down the witness about his knowledge of
Your Honor,
in just a minute, maybe. Go ahead.
Your Honor, the question is whether or not during the testimony of Mr. Offshay that there was any scientific basis given for the conclusions that he drew.
He don't know that, Judge.
Well, he heard the testimony.
I'm going to allow him to give his opinion in that regard.
I did not hear any report as to if the same procedure was applied by himself or someone else that he may have trained, that he would have arrived at the same conclusions.
And in the scientific community, if you want to have your theories accepted as valid, what do you do?
Typically what is done and is the customary procedure is that you write up the results of your study, you describe what you did, what results you have, and what you believe are the implications, and you submit that paper to a scientific journal in your field or in a related field where it is reviewed by other peers, that is, other colleagues with similar training, not necessarily similar views, and based upon their review, your paper and your results are either accepted or rejected. In addition, what one typically does as well is send in a very short description of your paper and your findings to professional societies who have people who review to determine whether or not the scientific method is worth reporting and your results worth reporting, and they might invite you or may choose not to invite you to present your findings at a scientific meeting.
Okay. Was there anything in Dr. Offshay's testimony yesterday that indicated that his theories had been published in any accepted peer review articles?
I did not hear any evidence of that.
Now, is a Pulitzer Prize, is that an award given for scientific achievement?
No, it is not.
Okay. And would that have any more to do with the qualifications of a sociologist than the Heisman Trophy?
It would not.
Now, you have reviewed the test and the report of Dr. Wilkins, and I would first like to direct your attention to the IQ test that was used. Which one was that?
That was the Wechsler Adult Intelligence.
I don't know that he needs to. He can refer to the report and give his opinion based upon the report and data. You made that same objection the other day. You won't allow me to do that. I mean, that's something he can do.
I would ask that the jury be instructed to disregard his testimony regarding Dr. Offshay. He's not an expert in the same field as Dr. Offshay, and his stuff about scientific methods in biology has nothing to do with
scientific method is a concept, and it's used in mathematics, it's used in engineering, it's used in every field. And the scientific method is something that any educated person that employs the scientific method can give an opinion. And in my opinion, this conforms to the norm of the scientific method. And that's really all he's done.
Thank you.
Now, Doctor, which one was the IQ test that was performed?
The Wechsler.
Arranged?
Yeah, that's people can respond very easily, and you make the therapeutic process almost seem very easy. But on the other hand, they can be belligerent, they can be manipulative, they can be sullen, they can say, "I don't want to do this." There are a whole range of responses. Just because someone has an IQ of such and such number or such and such score or does not necessarily correspond to how they will react in terms of being persuaded to change a particular behavior that they might be engaged in.
In other words, the person with a low IQ may be just as belligerent and stubborn as the person that's a genius.
That's true.
Now, you heard testimony yesterday about how you determine if someone is being persuaded or is being subjected to suggestibility.
Yes, I did.
Okay. What would you have to have in order to, or what would you want to have in order to determine if a person at a particular period of time was being influenced or manipulated or subject to suggestibility?
There would be two things that I think would be important, actually three, but two very important. One, I would want to have some evidence that the person's ability to remember or to recall information that he may have or she may have experienced and or heard was in the normal range or kind of what we would expect for someone that particular age. Mm-hmm. The second thing that I think would be important related to suggesting something or influencing something is to have some kind of permanent product or documentation of that interaction. That is, a videotape, certainly at least an audio tape, because influencing and persuasion, much like in therapy, is not only verbal information that's being given and received, but it's also nonverbal cues as well that need to be examined and evaluated.
And so you would need to know not only what was said, but how it was said and that sort of thing before you could even begin to speculate as to whether someone was suggested or influenced to act a certain way?
As part of the training to become a clinical psychologist, as well as in allied fields such as social work and other mental health, counseling, psychiatry, for example, it is customary, for example, for therapy sessions for trainees to be videotaped and for you to be monitored because of that and those influences. That is a typical part of training. And so to make judgments about that, I would think that that would be equally important.
Now, Doctor, there were indications in this test that the defendant, I believe it was on the Wexford memory scale, showed some marked deficits in visual and verbal recall.
Yes.
Okay. Now, if you were presented with a hypothetical where a person had viewed, participated, witnessed an event that occurred approximately 35 days earlier, and he had these deficits in memory that are indicated in Dr. Wilkins' report, would it be surprising for that individual to state facts in a less than chronological order?
It would not be surprising. In fact, that's what I would expect.
Okay. Would you expect that person to have difficulty in remembering specific details?
Yes, I would.
Okay. Would you expect that the most graphic occurrences during that time period would be the things that would be most vivid in the memory?
That would seem very likely.
Now, you indicated that you work with adolescents that are involved with drug abuse and that sort of thing?
That's one of my research areas of interest, yes.
Okay. And would huffing gasoline, does that have an effect on your memory?
Unfortunately, there is some evidence that suggests that it certainly has some effect on the brain. Specific impairments we are unclear about, but it is generally recognized that individuals who huff or inhale solvents of one sort or another can do tremendous damage to the brain. Now, whether or not these damages are reversible is unclear at this point.
And it would affect memory not only during the time you're under the influence of the gasoline, but also possibly down the road.
Yes, that is certainly a consideration.
Okay. And marijuana and alcohol use, do they impair the ability to recall events?
Yes. Alcohol, as many people know, is a depressant, and when we drink a lot of it, we may not remember exactly what we do.
Now, if you would, in referring to the diagnoses that Dr. Wilkins made, do those diagnoses fit, or how significant are those diagnoses? Does this indicate somebody that's a sick individual?
If the word sick is referring to someone who is in significant psychiatric distress, no, they do not. His Axis 1 diagnosis, which is typically used to indicate mental health or a mental disorder, is adjustment reaction. Many individuals during the course of their lifetime experience what we call an adjustment reaction, which is just some impairment in your ability to function day to day because of some particular event or some situation. I believe that was his Axis 1 diagnosis, and I think that is not a significant psychiatric disorder.
Anything in the diagnosis that indicates to you that this defendant had any significant psychiatric difficulty at the time of this examination?
No, it does not. In fact, it's stated in the report that in 2 or 3 places that there was no marked psychopathology.
Okay. Did that necessarily jive with the very detailed description you heard Dr. Wilkins give as to this defendant's emotional insecurity, his lack of intense feelings of inferiority, insecurity, lack of self-confidence, self-esteem, did all that fit with what you see as a pretty insignificant diagnosis?
No, there was not a great correspondence between some of his descriptions and the diagnoses, and also the test results. When I was evaluating or looking at this report, he would report the findings, and then on some occasions he would make elaborate details of what appeared to be a relatively benign result.
One second, Your Honor. Pass it with me.
What are you again?
I'm a licensed psychologist.
Okay. You're not a social psychologist, are you?
No, I am not.
Okay. Do you know anything about false confessions or police interrogation techniques and influence?
No, I do not.
Okay. Do you have an opinion as to whether a police station is a coercive setting or a tranquil setting?
I don't have any such opinion.
Okay. Now, you mentioned earlier that, if I heard you correctly, and if I didn't, please tell me, that you thought it was important to videotape.
Yes, it would seem to me that would be an important...
If it's not videotaped, it's really kind of hard to figure out what happened, isn't it?
It would seem to me that would be my opinion. It would be difficult to accurately come to a conclusion.
Doctor, is there a difference between not remembering something and just getting it wrong?
Well, if you get it wrong, you didn't remember it.
Thank you. When did you get retained to work on this case by the state?
Could you define what retain means?
When did you know you were going to be working or testifying on this case?
I knew about the possibility that might occur a month ago, perhaps, maybe. But nothing was definite. I was simply asked to look at some material.
Your name didn't appear on any witness list, did it?
Your Honor, I object to that question. It's improper. Mr. Stidham.
I'll withdraw it, Judge.
All right.
And you don't know whether you're going to get paid for this or not?
No, I do not.
Okay.
I would assume that I'm not, because it hasn't been mentioned on the front end.
Okay. How much time have you spent talking and visiting or evaluating Mr. Misskelley himself?
I have not spent any time.
Absolutely.
Just one thing, Doctor. Yesterday, Dr. Wilkins was talking about how certain tests showed that this defendant was at the third grade, performing certain skills at the third grade level or second grade level.
Yes.
Okay. Does that mean, from a professional standpoint, does that mean that he's like a third grader?
No, and that's one of the difficult things, at least in my field, is that we tend to use results in order to give people frames of reference. And so when we say that a person who is, who in this particular case is 17 or 18, is like a third grader, the reality is that they are not like a third grader. Their responses were similar to the way other third grade children responded. Now, particularly what Dr. Wilkins was reporting was how well the defendant could spell words, how well could he calculate math problems on paper and pencil, and how well he could read words that increased in difficulty. Those are academic tests, it's an academic measure, and so the responses he gave grossly were very much like a normal or an average second, third, or fourth grader. Obviously, someone who is older than 9, 10, or 11 obviously has many more experiences, and so it would be inappropriate to say they are like someone under their stated age.
Okay. In other words, that's basically they're like a third grader in terms of academic achievement.
They are responding similar to a child in third grade, an average child, yes.
And Mr. Stidham asked you if you were a social psychologist, if you wanted to be a licensed social psychologist, you couldn't get such a license in the state of Arkansas, could you?
No, you could not.
No further questions. Could anybody?
No, no one. There's no board for that particular discipline.
All right, thank you very much. You may stand down. Any reason to keep you in attendance? No, sir, no, just free to go.
Thank you.
All right, raise your right hand, please, sir. You swear to tell the truth, the whole truth, and nothing but the truth in the matter now pending before the court, so help you God. I do.
Could you state your name and where you live to the jury?
My name's Keith Douglas Mercier. I live in, I used to reside in Highland Trailer Park.
All right. And have you ever been to Dice Wrestling?
I went down there one time with some friends, not wrestling.
Okay, but you went down, were they wrestling?
Yeah, they were. Yeah.
All right. And do you recall whether or not that was before or after the murders of the 3 children?
That was before.
Okay. I want to show you what's introduced as State's Exhibit 103 and ask if you recognize the signature on the very bottom.
Yes, sir.
All right, whose signature is that?
That's mine.
All right, would you mind taking this yellow highlighter and highlighting that for
Okay.
jury? Do you recall signing that?
Yes, sir.
All right. And how many times did you go?
One time.
One time?
One time, best of my knowledge.
I don't have any further questions.
Mercier, is that
Yes, sir, that's correct.
with a name like Stidham? You got to be real careful. You got to be sensitive to people's last names.
Yeah.
Are you on the search and rescue team?
Yes, sir, I am.
Do you remember May the 5th?
Yes, sir.
You remember going to the search and rescue meeting with Kevin Johnson?
Yes, sir, I recall.
And at the meeting, some of the guys have scanners.
Radios in the truck, yes.
You told me out in the hall that night at the meeting you came over the scanner that the boys were missing.
I didn't hear it. Someone else said something about it, but I didn't hear it personally.
Absolutely.
I don't have any questions. Why don't you may stand down and you're free to go.
All right, thank you.
Call your next witness.
Call Joe McCafferty.
I believe you've been sworn. No, sir. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter now pending before the court, so help you God?
Yes, sir.
Would you state your name and occupation for the jury?
My name is Joe McCafferty. I'm a corporal of Berrien Police Department.
How long have you been in law enforcement?
21 years.
Officer McCafferty, I want to direct your attention to May the 5th of 1993. Have you been shown a report of that?
Yes, sir.
All right. And do you recall going in response to a dispatch to that area?
Yes, sir.
All right. And looking at that report help refresh your memory?
Yes, sir.
All right. Where did you go and who else went when you responded to Highland Park?
I went to Highland Trailer Park along with Officer Oliver with Merriam Police Department and Deputy Dollahite,
All right.
Crittenden County.
And let me show you what's been introduced in State's Exhibit 2A. And if you could indicate on that map what entrance that you entered the park, and if you would use this red marker.
Okay, this is Highway 77 here?
No, that's Service Road.
Service Road? Okay. I'm trying to know what entrance it is here.
North would be up this way.
Okay. That's what I'm trying to figure out on this thing here. Which way we came in. Okay, this is Service Road coming up alongside Highland?
Mm-hmm.
Okay, I came in the very first entrance, which would be right along here. This would be the same way.
All right, same way as this one?
Right.
Okay.
Be exactly the same way here. This is the first entrance here.
When you say exactly the same way, the jury can't see what you're referring to. Are you referring to the same way as the pink mark?
Yes, sir. This is the very first entrance coming into the park. This is the last entrance, which is by Hex Record Service.
Okay. And if you could take the red marker and mark the route you followed.
Okay. And that's about where I stopped, right where
Where you stopped, the darker marker?
Yes, sir, right there.
Okay. Now, put that back down. Now, when you arrived there, approximately how many people were there?
Not counting the officers?
Not counting the officers.
Would be around 6 that I've seen.
All right. And do you remember any of the people that were there?
I recognized one of them, Mr. Stidham, I believe was one of them that was there, and there were some young children, some young ladies standing there.
All right. When you say young children, what ages are you talking about?
Oh, I don't know, maybe around 13, some younger than that, some little kids. There might have been some young ladies there in their early teens.
Okay. And are you acquainted with the defendant?
Yes, sir.
All right. Were you acquainted with the defendant prior to May the 5th?
Yes, sir.
All right. Did you ever see the defendant on that day?
No, sir, I don't recall seeing him there when I was there.
I don't have any further questions, John.
Officer, you don't recall?
No, sir.
I mean, you're not real sure.
I just don't recall seeing him where I was at.
Nothing further.
That's... I'm going to show you this radio log that's been introduced as Defendant's Exhibit 4. What time does it show that y'all checked off the scene or left that area?
Be right here.
And what time is that?
1859.
What does that mean?
Be around 6:43 or 6:59.
6:59?
Yes, sir.
Okay, thank you. Did y'all ever go back after that?
No, sir. That was the only time I went there.
Okay. I don't have any further questions.
You may stand down.
Call Jason Oliver. He'll need to be sworn as well.
You swear to tell the truth, the whole truth, and nothing but the truth in the matter now pending before the court, so help you God. I do. Come right around.
Would you state your name and occupation for the jury?
Jason Oliver, I'm patrolman with the Marion Police Department.
And Patrolman Oliver, I want to direct your attention to May the 5th, 1993. Have you been shown a report in regard to that day, in regard to an incident at Highland Park?
I was shown a report, and I was also there at the time.
Okay, well, I was getting to that. All right, and you were there?
Yes, sir.
Who else went to that scene when you went?
Corporal Joe McCafferty with the Marion Police Department and Deputy James Dollahite, Crittenden County.
And if you would take this blue marker and mark the route that you followed going into Highland Park, this is north toward Marion, this is the service road.
Okay.
All right, and you've marked on the Exhibit 2A that you came in a different entrance from the other officers?
That's right.
All right, is that further to the south?
Yes, it is.
And when you got there, about how many people were there on the scene? Not counting the officers.
I'd say 7 or 8.
Okay. And were you acquainted with the defendant on May the 5th? Know who he was?
Yes, sir.
Okay. And did you see him there?
No, sir, I did not.
I don't have any further questions.
You remember who was there, the other people?
I remember faces. I could tell you probably maybe one name, but that's it.
Nothing further than that.
Anything else?
No.
All right, you may stand down. We'll excuse and speak up. Call your next witness.
Honor, state we call Gloria Wilson. Oh, you mean
You hadn't been sworn in. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth in the matter now pending before the court, so help you God. Come right over here, please.
Would you state your name, please, ma'am?
Gloria Wilson.
And Ms. Wilson, where do you live?
West Memphis.
Okay. And back on May 5th of 1993, were you conducting alcohol safety programs for people who had received DWIs and were required to go to alcohol safety school?
Yes, I was.
Okay. And when did you start? When was the first time you started doing those classes?
May 5th of
Okay,
93.
so that was the first night you'd ever done that?
Yes.
And when did those classes start?
The times?
Yes, ma'am.
6 o'clock in the evening.
Okay. And when would those classes end?
Well, anywhere from 7:30 to 8 o'clock. But on these particular ones, they ran closer to 8 o'clock because it was my first session and I was being evaluated.
When you say evaluated, there was somebody there observing what you were doing?
Supervisor.
Okay. And so how late did this class that you conducted on May 5th, how late would it have gone to?
At least 15 days.
Okay. Now, I'd like to show you what's marked as State's Exhibit 2B, which is kind of a sign-in sheet. Is that a sign-in sheet you used, a copy of one that you would use for people to sign in on at the meetings?
No, this is a list that I make, and when they come to class, I just call them by name and check and see if they're in the class. But I do have a list that they do sign. They sign in.
Okay. Have you got that with you?
No. Maybe in the first particular session, he might have not have signed in.
Okay. Well, this indicates
This indicates that I did call them out by name and check. The checks indicate that they were in class.
Okay. And who is the last one on this roster?
Jessie Misskelley.
And that's Jessie Misskelley Sr.?
Yes, it is.
And does it show that he was checked as being present on that first class?
Yes.
And that would have been on May 5th, is that correct?
Yes.
Your Honor, at this time, we've moved to the introduction of State's Exhibit 2B.
All right, it may be received without objection.
May we exhibit it to the jury, Your Honor?
Yes, you may.
Did y'all ever introduce that receipt, that big blow-up of the receipt showing that he was there on the field?
I think we just introduced the original receipt.
No, that's a different receipt.
It may be.
Here. Yeah, okay. I'd like to refer you to defendant's exhibit, number 5. Is that a receipt to Jessie Misskelley Sr. reflecting that he paid $50 for that class on May 5th?
Yes, it is.
Okay. And so based on your testimony, persons attending that class would not have left until 7:45 at least on that day.
Right, you may stand out. Any reason to keep her here?
No.
You're free to go. Thank you, ma'am. Call your next witness.
You're the same Detective Ridge that previously testified.
Yes, sir.
Detective Ridge, in your experience as an investigator, in the past, have you attempted to obtain phone calls records of phone calls that were not long distance local calls?
Yes, sir, I have.
All right. And are you able to get that type of record?
No, sir.
I don't have any further questions.
No questions. No questions. All right, you may stand down.
Your Honor, at this time, the state is rest.
Okay, anything additional?
I just smoked one. Of course, I didn't show.
Before we renew our directed verdict motion in chambers.
No, you can do it right here. You want to add any additional matter not previously covered?
Oh, I would like to briefly go through it if we can do that in chambers while we're doing it.
No, just a minute. I'll just let the jury go because we're going to have to go over the jury instructions anyway. That'd give them enough time?
Well, I think 2 o'clock's fine.
That'd be all right.
All right, ladies and gentlemen, both sides have rested their case, and the testimony is concluded. I'm getting ready to give you a recess. It's still important that even though both sides have rested their case, that you not attempt to discuss the case among yourselves or with anyone until it's finally submitted to you. I'm going to give you a long lunch break until 1:30, and the reason for that is the court will have to hear and rule on some motions. I'll have to go over and discuss the jury instructions with the lawyers. I don't anticipate that to take too long, but I want to give them a little bit of time to collect their thoughts, because as soon as I read the jury instructions, then they'll argue their case. So that's the reason for the 2-hour lunch break. So again, you're reminded of the admonition not to discuss the case or allow anyone to attempt to discuss it with you or in your presence. And you may stand in recess until 1:30. All right, gentlemen. I don't anticipate us having a whole lot of problem on these instructions. You want to tackle them now in the back?
I prefer that, yes, Your Honor.
The verdict forms may be a little more challenging.
I think that needs a little help, I think.
But that's something I assume we'll have some time to
Well, you know, there was one thing Mr. Crowell offered an instruction on the diminished capacity, or what do we call it, in capital murder. There's a new statute, a 93 statute, that where it's an allegation that a person is mentally retarded, that goes on the death penalty and only in the punishment phase. But I'm raising this now because, as I recall, Dr. Wilkins' testimony and the last psychologist that testified, each of them testified affirmatively that he was not mentally retarded.
Your Honor,
So there is no evidence to the court that he was mentally retarded.
Your Honor, again, the Arkansas legislature has promulgated that definition. It is not the same definition that is used by, it is a clinical definition used by the
Well, we can argue that later, but I'm just voicing my view of the status of the evidence, that there is no evidence to suggest that he is other than, at the very worst, a borderline functioning individual.
Use the term mostly mentally deficient. We've tried to steer away from the term mentally retarded. We've used the term, I don't think.
Well, I think the statute uses the term.
But the statute's definition of mentally deficient or retarded is different.
It refers to sub-average general intellectual functioning, Your Honor, and that's different than just saying somebody with this particular IQ or this particular IQ classifies as
Well, right now, there's no testimony to that effect at all, other than the hearing that was conducted in Osceola, and I recall the testimony from that hearing. But if it's to be submitted to the jury, and it may be talking about something right now that may never come up, but if it does come up, I anticipate that you'll have to then redirect that testimony to the jury in the punishment phase.
I fully anticipate that.
Oh, okay, all right. Well, let's go back here and go over the rest of it. Yeah, we're just gonna talk, and then we'll let Barbara know what we need to put in. Huh?
You can discuss it a little bit and when you get ready.
We're gonna talk about it, and then whenever we need to go on the record, we'll bring it up.
Thank you, Your Honor.
I'm gonna let Barbara go get me a sandwich. Sheriff, are y'all?
I can have you one, bro.
No, we can send our secretary.
Okay. Just cheeseburger. Cheeseburger.
I'm ordering
Okay.
what, McDonald's?
Yeah, that's fine. Is that enough money?
Victim's pictures before and after victim's pictures, and the rest pictures.
We're right there.
We're probably on the state line.
He only knew how to handle it, and he said that that was before. I didn't ask him what he signed, that's what he should have signed. Well, he testified that he only went one time.
Do you have him bring you a sandwich? Yes, sir. We're sitting You want to let her get you a sandwich? That's what I did. I sent out for a cheeseburger.
Make a list.
I'm always we had a club sandwich
I wouldn't mind it, like a club sandwich.
Get John a club sandwich.
two more, anybody else? Just get four, Brenton.
Okay, who else wants one?
Brenton, John.
Okay, 1, 2, 3, 4, 5, 6, 7.
Yeah, well, money, boys, and money. You know, it's pretty profitable work for the prosecutor's office. You only end up blowing money.
I'm gonna go buy a little grocery store.
What's the good thing is I'm going with over, I'm on with
I think I've got it. I'm covered now. You get candy on
maybe I'll check when I get over there. Let me see how much they are when I get there, and then I'll square up with everybody.
Just where I want to get back to.
So I need 6 club sandwiches. I'm only going for 6 people, is that right?
I guess that's right. Okay.
Or you want any chips or anything?
Yeah.
You guys want some chips?
You want chips or anything?
No, I'll
Something to drink? Or?
I'd like a Coke.
One real Coke.
Ask Bryn if you want something to drink.
Bring one thing to drink.
No, I'll just get one out of the refrigerator.
What? You get chips or anything?
I don't want to see back.
You better get a drink. It might not be back.
Little cafe right there across the Garland Wall. Hey, that's a good place to eat. I know you still can watch a lot of things.
That all we could do is say, we're glad this one's over, and we'll, move on to the next one. I guess we'll play. And if y'all end up getting yours, I might contact somebody else, but I can afford 2, 3. This one assistant.
Is the judge
Yeah.
You want to check with him?
Does he, I don't know whether someone else was going to go there.
I'm gonna let you say this and this. Try to do everything we can.
Huh?
That's
what I thought.
I really think it's more like a break.
I'm sorry, I couldn't hear you. Wasn't there that was over the boat?
Nice.
You remember who Bojangles was? Really? It was a mystery. Oh, Mr. Bojangles. I thought you meant the person at Bojangles. And that's the person. I don't even think we ever found him exactly. He's a mystery. And Mr. Bojangles. And that fits in with these black faces that we talked about. These black faces. We got a maniac minstrel out here. Singing his way and eating chicken.
I didn't get to see your drawings yesterday.
I was glad. Did it look like one? Did it really? Let's see. Really does? I wanted to see Wilkins' tree because I think he has the same. I understand he has the same drawing.
You know what's so crazy is it would be about for them to bring the actual drawing with them to court. That is absolutely transcript of your client's statement with you. So here, by the way, here's what he told me last week when we met.
Hey, I think there's some sense. Ooh,
that house really does it.
John.
Thank you.
You know what it is?
They all get an advertisement. Every advertisement that you see has some sort of phallic thing to it these days.
Well, you know,
like these Coca-Colas erupting out, you know.
Well, it actually says if they draw a hole in the tree,
I was
that's when you can work out.
That means they won't. The one commercial board of that Pierre Cardone, that cologne. Of course, it looks just as phallic as it gets, and then the commercial, the top blows off, and the cologne comes bubbling out like champagne. I'm serious. I've seen that commercial. It's like a mission on it. I was real concerned. Well, let me ask you this: is the bicycle test, the clock test, and the
proper? Yes, it is. I've done it in a million cases. It's never been made.
Let's put it this way: if they're chuckling during closing, I'm gonna do it.
Hey, John, you know where the brown rope in this case came from? The brown rope in this case really came from the prosecutor's cross-examination of Offshay.
He got the brown rope out when he should have left it in his briefcase. I got to be on. That's my personality.
I agree with that. That's one thing we agree on.
I've been killed before. I've been.
You guys, dismiss the case. I give Jesse a job.
I called one like that with me. Let us think about the other day, the guys that was reconstructing that. They just kind of. You can't do that, no matter what you ask them, they get a warrant to say what they want to say.
Well, but if the good cross-examiners make that vividly apparent to the jury that that's all they're doing. They aren't. Unfortunately. I should have said, you're still a manipulative techniques, aren't you? What should I say next time?
I know it's a doctor now, it's morning with Mr.
That's the truth. He's no more a doctor than I am or you are.
He's got a PhD.
Well, so what? I got a JD.
You can call yourself a doctor. Arkansas Supreme Court says you can't call yourself a doctor.
What makes...
Oh, isn't there, there's a guy over in Memphis who calls himself doctor.
I'm just as educated as Offshay.
Well, but that guy, the guy y'all put up there was a PhD, and I called him doctor.
But he's a licensed psychologist.
So when you had professors in college who were doctors, you wouldn't call them doctors?
You must have made bad grades in college. That's how I call them, Mr. They made a C- or something.
The ones that are filled with self-importance insist on being called doctor.
The chiropractor is doctor.
I'll call it Neil calls him chiropractor or whatever he calls him by the
There was a guy at Mercier that practiced law. His name was John McLaughlin, and he called himself Dr. John McLaughlin.
But I'm serious. You got a doctoral degree.
Sure, you got a JD.
It's a doctoral degree.
The Arkansas Supreme Court, though, there was a guy down in outside the Fort Smith who started. He was one of the first banks that got the JD. There used to be LB or something called them. And then they called them.
I think it's easy to get a PhD than to get a law degree.
You can take forever, and you can
Anyway, he started
have like a little dissertation with that.
Well, I'll say this.
Takes a lot of time.
It ain't no such thing as a bar exam. Because if you don't get your dissertation right, well, you just go back and work on this.
Not calling himself out.
So in other words, when your wife finishes her PhD, she'll be smarter and more educated than you.
She'll never be smarter than me.
Oh, I'm going to tell her someday I'll meet your wife.
You know what's so funny is there's not a better woman in the world that calls Robin on the call.
If she had a PhD closes, would she?
No matter who listens, no matter who listens.
Yes, probably. If John didn't call Robin, she'd be mad, wouldn't she? If John didn't call a doctor, she'd be upset, wouldn't she?
She'd be a psychologist, so that's different. That's a field that's recognized. That's where there's actually a board that licenses.
So when she got out of school, before she got her license, she wasn't a doctor?
Cal Berkeley, they just hire him to get it up the street.
I want to so bad to ask, isn't it true that y'all allow folks to go to school nude? You went to school, what, for a year, nude? Went to class, nude?
You don't think O'Shea's highly educated man?
Oh, he definitely is, and he is an expert in testifying.
You know, I used to use the expression a testifying fool, but that's not quite appropriate for him. I guess.
He was on 48 hours.
Yeah, hey, if we talk ugly in here, you better turn this mic off.
Yeah. So surely there's not a switch on it?
No.
I mean, even though they're for the American Psychological Association, Sociological Association, have opposed it. They submitted briefs, supposedly.
I spent all those Saturdays getting phone calls from all over the country. People found out he was coming here, and it was like, well, let me tell you this and that about him. But they said the worst thing is he didn't inherit it. He said social psychology is just, it's like vapor.
By the way, he knew Malcolm Feely that taught me, he's from Berkeley, that teaches, he's a sociologist in the law school, and he teaches scientific evidence. And he knew Feely real well. he also knew Jim Richardson, and apparently Jim, Dr. Richardson from the University of Nevada, has written a lot of papers on Scientology. Is that what it's called?
Yeah.
But apparently this guy said that he testifies for the Moonies and for the Weirdos. But I didn't know that. I just knew Richardson had written a bunch of papers on cults, but they know each other.
He settled. He got a $600,000 settlement for a suit against the Scientologists.
Did he?
Yeah, because they criticized him or said publicly made some statements.
What did he say on TV last night?
I can't afford that.
What did he say on TV? Did any of y'all hear that last
I
night?
just seen his face. I didn't see what he said or what
Well,
was
I didn't, but somebody that did say it, saw it, said that it didn't have anything to do with his case.
It was on 48 hours.
Did you know that the Maricopa County Sheriff's Department is as the most infections? Okay, go ahead and go. They're hired also to come in and fix all the interrogators, how to properly interrogate suspects.
That's what so they want you to get him testified against them.
That's it.
Don't worry.
Oh, man.
Y'all know where you're gonna be when I get back? Be back here?
I'll be right
Not sure.
here.
You left yet?
She said be 20 minutes for the
Oh, you called? He said,
Look down.
geez. Slapping you?
Control yourself. I got it under control, Dan.
I'll guarantee you, he knew we could videotape again.
The fact is, you'll be more miserable for the next 3 days after this is over. Than
Basically, in there, he recommends that the police did.
Let me tell you something, and tell me if it's not true, it must be now. The 3 days after this case is over, you'll be more miserable than you were during the case.
What, think about, I should have done this, or should have done that, or?
No, you get in this state where it's just you're just obsessed with worrying about this matter. It's all you thought about, it's all you worked for, and all of a sudden, you don't have anything, you don't have it there, it's over, it's fine, but your body is just still kind of geared up, and it drives you crazy. People hate you don't want to be around.
You call my wife, and woman, this is coming, she's already changing the
That's what happened. I had been 3 weeks, and she said, well, I'm glad it's over. I said, yeah. And then when it's over, it's a lot worse than what's going on.
They bailed me out last year, but this year's gonna be a different story. I'm working more. Please don't break that. I hate that thing. It's too heavy.
It is heavy. I was trying to figure out what it is. Oh, it's made out of that.
It's not. That wasn't. We told them to put it on that stuff like this aerial photographs mounted on, and we got it back. It was like that. And it was too late to. Deal with Bryn on that. I don't know anything about.
John, would you get a yellow marker up here and show me where you live?
Show me where I live.
At least it's evidence. Examiner,
Where you
on
are?
what she's actually going to
You remember where you
testify
I have no idea.
I want to
Every
time you do
I found a picture of him.
What I would do, if you talk to her.
No, I'm not talking to first.
All I was.
I think you wrote my.
They know it's
Can
Can I have her tell her how to tell them who it's, would she mail them to them in the way that she mailed them down to them?
I would suggest that you get whoever your guy is and call her to discuss where to send to, and also the ground rules as far as, and I don't recall, I just going that Larimore thing, there were a bunch of questions about taking them out, remounting them,
And everybody else I think was it?
and I don't know if that would affect her, if she's gonna have objections.
And I'm serious, I know that y'all.
If that becomes a question, if your guy says, I can't handle it without remounting it, she says, God, you can't remount that, totally affects her reliability of information.
Well, she's already basically, all right, in other words, you don't have any objection to them communicating with about the proper way to transport them or to view them or to agree not to remount them without her permission. It seems to me that if she's examined them and reached her opinion,
He says, hey,
that, obviously,
here,
police car.
Issue of report
They're all
based on
down
what she's already viewed, not what she
And he
was
said,
later.
I do remember seeing
But
those pictures.
he may not have to be on.
Okay.
I don't want to create any conflict. I just want to look at it and see.
Well, I think what your guy would say would be he would prefer, his opinion will carry more validity if he can view it in the same stuff that she did without having to read it. I just know that the last time, the Alabama guys did that stuff on Larimore.
About the logs,
They
I didn't, by the way, I
read
don't know.
it because they didn't think the way it was mounted originally was appropriate. And we got into
I never did.
a problem with that, and they were very, they said, we're not gonna read down after we do
Anyway, what the radio law makes.
And that's all I want the guy to do. If he thinks that something like this is necessary, let us know and let us let the judge.
And contact Callahan, there was no opt-in report. He checked, and he was the one who went out.
All right, one last,
And he checked with Phillips, didn't have any.
one other thing. No, that's what I want to supply
I
back to
think
you.
that
The
is what
motion
he was
based
thinking
on what's
about.
already been said to me.
I know, but if
As much as you ain't got it in here to get it out.
Well, I know, but see, Hogger's not even
There was a
talked to
report
until
with the
September.
FBI issue about soil testing.
Jessie Misskelley tells us about it before.
The soil of Jason's booth and some soil samples from around that area. And they analyzed them and they said, can't make anything of it, but there's no, there's no individual listed as to who the signing agent is on the testing part. I either want to be able to, if we can't agree to stipulate
Oh, I don't think it
findings
makes a
that
difference.
that mudless and
I'm not gonna argue.
that came back.
Yeah, that's
there were 4 issues. I want to be able to know who the individual is.
It was a several pages.
To get them
Several
to-
pages.
Yeah, it was stipulate to the report. And since I don't know who that is, it's hard to issue a. So if y'all would let me know what I need.
This is
Okay.
or something.
But I can, you won't have any problems if I call Lisa and say, Lisa, you need to contact this gentleman.
Well, have your guy contact her.
Okay, I'll have him contact Lisa, and they don't have it, I can say it's okay if y'all communicate about how to do it. And he does what she does.
Manner indicated my views on the merits of the case. Opening statements, remarks during the trial, and closing arguments of the attorneys are not evidence, but are made only to help you in understanding the evidence and applicable law. Any argument, statements, or remarks of the attorneys having no basis in the evidence should be disregarded by you. I have not intended by anything I have said or done, or by any questions that I may have asked, to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any witness who testified. If anything that I have done or said has seemed to so indicate, you will disregard it. In considering the evidence in this case, you are not required to set aside your common knowledge, but you have a right to consider all of the evidence in the light of your own observations and experiences in the affairs of life. You are the sole judges of the weight of the evidence and the credibility of the witnesses. In determining the credibility of any witness and the weight to be given his testimony, you may take into consideration his demeanor while on the witness stand, any prejudice for or against a party, his means of acquiring knowledge concerning any matter to which he testified, any interest he may have in the outcome of the case, the consistency or inconsistency of his testimony, its reasonableness or unreasonableness, and any other fact or circumstance tending to shed light upon the truth or falsity of his testimony. An expert witness is a person who has special knowledge, skill, experience, training, or education on the subject to which his testimony relates. An expert witness may give his opinion on questions and controversies. You may consider his opinion in the light of his qualifications and credibility, the reasons given for his opinion, and the facts and other matters upon which his opinion is based. You are not bound to accept an expert opinion as conclusive, but you should give it whatever weight you think it should have. You may disregard any opinion testimony if you find it to be unreasonable. The state must prove beyond a reasonable doubt each element of the offense charged. On the other hand, the defendant is not required to prove his innocence. There is a presumption of the defendant's innocence in a criminal prosecution. In this case, Jessie Lloyd Misskelley Jr. is presumed to be innocent. That presumption of innocence attends and protects him throughout the trial and should continue and prevail in your minds until you are convinced of his guilt beyond a reasonable doubt. Reasonable doubt is not a mere possible or imaginary doubt. It is a doubt that arises from your consideration of the evidence, and one that would cause a careful person to pause and hesitate in the graver transactions of life. A juror is satisfied beyond a reasonable doubt if, after an impartial consideration of all the evidence, he has an abiding conviction of the truth of the charge. Evidence that a witness previously made a statement which is inconsistent with his testimony at the trial may be considered by you for the purpose of judging the credibility of the witness, but may not be considered by you as evidence of the truth of the matter set forth in that statement. In this case, the state does not contend that Jessie Lloyd Misskelley Jr. acted alone in the commission of the offenses of 3 counts of capital murder. A person is criminally responsible for the conduct of another person when he is an accomplice in the commission of an offense. An accomplice is one who directly participates in the commission of an offense, or who, with the purpose of promoting or facilitating the commission of an offense, agrees to aid, aids, or attempts to aid the other person or persons in the planning or committing the offense. Purpose is defined. A person acts with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. Jessie Lloyd Misskelley Jr. is charged with 3 counts of capital murder. This charge in each count includes the lesser offenses of first-degree murder and second-degree murder for each count. You may find the defendant guilty of one of these offenses, or you may acquit him outright. If you have a reasonable doubt as to which offense the defendant may be guilty of on each count, you may find him guilty only of the lesser offense. If you have a reasonable doubt as to the defendant's guilt of all offenses, you must find him not guilty. Jessie Lloyd Misskelley Jr. is charged with the offense of capital murder, 3 counts. To sustain this charge on each count, the state must prove the following things beyond a reasonable doubt. First, that with the premeditated and deliberated purpose of causing the death of any person, Jessie Lloyd Misskelley Jr. or an accomplice caused the death of Michael Moore in count 1, or Stevie Branch count 2, or Chris Byers count 3. Purpose is defined again. A person acts with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. If you have a reasonable doubt of the defendant's guilt on the charge of capital murder, you will then consider the charge of first-degree murder. To sustain the charge of first-degree murder, the state must prove beyond a reasonable doubt that Jessie Lloyd Misskelley Jr., with the purpose of causing the death of another person, caused the death of Michael Moore in count 1, Stephen Branch in count 2, and Christopher Byers in count 3. If you have a reasonable doubt of the defendant's guilt on the charge of first-degree murder, you will then consider the charge of second-degree murder. To sustain the charge of second-degree murder, the state must prove beyond a reasonable doubt that Jessie Lloyd Misskelley Jr. knowingly caused the death of Michael Moore in count 1, Stephen Branch count 2, and Christopher Byers in count 3 under circumstances manifesting extreme indifference to the value of human life, or that Jessie Lloyd Misskelley Jr., with the purpose of causing serious physical injury to Michael Moore count 1, Stephen Branch count 2, Christopher Byers count 3, did cause the death of Michael Moore, Stephen Branch, and Christopher Byers. Knowingly is defined: a person acts knowingly or with knowledge with respect to his conduct or the circumstances that exist at the time of his act, when he is aware that his conduct is of that nature or that such circumstances exist. A person acts knowingly with respect to a result of his conduct when he is aware that it is practically certain that his conduct will cause such a result. Serious physical injury means physical injury that creates a substantial risk of death or that causes protracted disfigurement, protracted impairment of health, or loss or protracted impairment of the function of any bodily member or organ. In order to find that Jessie Lloyd Misskelley, Jr. acted with premeditated and deliberated purpose, you must find that he had the conscious object to cause death and that he formed that intention before acting as a result of weighing in the mind the consequences of a course of conduct as distinguished from acting upon sudden impulse without exercise of reasoning powers. It is not necessary that this state of mind existed for any particular length of time, but it is necessary that it was formed before the homicide was committed. If you find Jessie Lloyd Misskelley, Jr. guilty of capital murder, first-degree murder, second-degree murder of one or more counts, you will so indicate on a verdict form to be given to you. If you find Jessie Lloyd Misskelley, Jr. not guilty of one or more counts, you will so indicate on the appropriate forms. In your deliberations, the subject of punishment is not to be discussed or considered by you. If you return a verdict of guilty on any charge, the matter of punishment will be submitted to you separately. Was there anything else, gentlemen? You may argue your case. Do you want the verdict forms? I got them here.
We all appreciate your willingness to serve as jurors in this case and take time away from your families and your jobs to be with us and help us see that justice is done. In this case, when you became a juror, you recall standing at the first and you took an oath. And you took an oath to base your verdict solely and exclusively on the law as Judge Burnett's just given you and the evidence as it comes from this witness stand. Not speculation, not conjecture, but on the evidence as it comes from this witness stand. And that's all that anybody can ask you to do. In the judge's instruction also, he mentions sympathy. Well, ladies and gentlemen, this is not a case about sympathy for either side, and it's natural for you to feel sympathy. But in this case, we don't want you to feel sympathy for anybody in the case. We don't want you to allow that to affect your decision in this case. We submit to you, after you've looked objectively at the evidence in this case, at the testimony in this case, that you will return an appropriate verdict of guilty to 3 counts of capital murder. And in this case, Judge Burnett has instructed you that in order to sustain a conviction of capital murder, in order for you to return a verdict of guilty of capital murder, the state has to prove 2 things beyond a reasonable doubt on each count. That is, that with the premeditated and deliberated purpose of causing the death of another person, this defendant or an accomplice caused the death of Michael Moore on count 1, Stevie Branch on count 2, and Chris Byers on count 3. Now, in regard to the reference to an accomplice, the judge has given you an instruction on accomplice. And in this instruction, he tells you that a person is criminally responsible for the conduct of another person when he is an accomplice. He's just as guilty if he's an accomplice. And an accomplice is one who either directly participates in the commission of an offense, or who, with the purpose of promoting or facilitating the commission of the offense, he aids, agrees to aid, or attempts to aid the other person in planning or committing the offense.
Now, the definition of purpose is on here too, and these definitions are real important. And if you look at it, you'll see that a person acts with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. I'll lose my voice. Now, what I would like to do now is take the elements of the offense and go through with you the element that we have to prove and what the evidence has been in this case. First, that with the premeditated and deliberated purpose of causing the death of Michael Moore, Stevie Branch, and Chris Byers. This defendant in his tape, let me back up, this defendant in the statement before he admitted being present, he tells Detective Ridge and Inspector Gitchell that he has a phone call the day before the murders and that he's told that Damien and Jason are going to West Memphis and they're going to get these boys and hurt them. He also testifies that at one of these cult meetings he mentions that a photograph of not just some boys but these boys is passed around at this meeting. Now, Miss Byers testified about her son coming in a month or so before and saying about how some strange man all in black had taken her picture, taken the son's picture, Chris's picture. He also stated that Damien had been watching these boys. He had been stalking these boys. Premeditation. In looking at premeditation, the injuries themselves speak loudest. Multiple skull fractures. Chris Byers bleeds to death, and Stevie Branch and Michael Moore are drowned. Was there a conscious object to cause death? Unquestionably. I don't believe anybody could dispute that. The second element is that the defendant or an accomplice caused the death of Michael Moore, Stevie Branch, and Chris Byers. The defendant himself, in this taped interview, describes this event. He describes his participation, or what he says is his participation in this event. The defendant's own expert says that the natural inclination of a defendant is to lessen his involvement in the offense. And I'll come back to that a little bit later. So he describes it for you himself. In the way he describes it, it reveals a premeditated and deliberate murder, all the way tries to lessen his own involvement. Now, these alibis, being in Highland Park and wrestling, this was a parade of the defendant's friends. You saw the yellow ribbon. The judge tells you in judging credibility, you judge demeanor, the way the witness testifies, whether there's, and I'm not giving this word for word, so rely on what the instruction says, not what I say. Whether there's any reason not to be telling the truth, any bias, anything to be gained from the outcome of the case. And when you look at the people with the yellow ribbon, the bias is obvious. They're here to try to help the defendant. Now, when you analyze their testimony, and this isn't a real impressive professional little diagram I've got here, but when you analyze their testimony in regard to Highland Park, and of course you can't see this, but I'm still going to refer to it because it helps my memory. The testimony about where the defendant was up until about 5:30 is really pretty consistent. It's pretty consistent among the witnesses. But when you get to the crucial time around 5:30 or 6 o'clock, these witnesses have this defendant in 3 or 4 different places at the same time. You look at it at about, Susie Brewer. She's got around 6 o'clock, between 5:30 and about 7, she's got her and the defendant on the street together and at Stephanie Dollar's house. If you move down to Jennifer Roberts, she's got at 6 o'clock the defendant and Christy Jones on the defendant's porch. Christy Jones says that from beginning about 5:30 or 6, she and the defendant are on her porch by themselves and for about an hour and a half. So anywhere from 5:30 to 7 or 6 to 7:30, she's saying that they're sitting on the porch all by themselves. If you go down to Mr. Hoggard, he puts at 6:30 Jessie by himself out in front of Stephanie Dollar's house. Not on the porch at the defendant's, and not with Susie Brewer down the street. Mr. McNeese says that about that time that he sees the defendant at this police car, which is down the street from the defendant's house. And finally, Jesse Sr. says that he sees the police are there when he gets home from DWI school. Well, the DWI school doesn't leave in until almost 8 o'clock, and if you look at this radio log, you'll see that the officers checked off the scene there right before 7 o'clock, or 8 o'clock. Anyway, it was at a time when they had already left by the time Mr. Misskelley Sr. got home, or even left where he was. So this is all totally inconsistent. And then when you go to the wrestling alibi, that was a total mess. You have Fred Revelle, the only person who comes to the police and says, look, I think y'all may have made a mistake. He was with me, and here's why he was with me. We had gone wrestling. It was me and Jesse and one other person, I believe he said, and in his first statement to the police. And I know it was that day because that's the day we paid the money. So the police, naturally, doing their job, they go out and investigate to see if he's right. That was the defendant somewhere else? And lo and behold, what do they find out? The money was paid a week before that. And they get a receipt to prove that. Well, then when Mr. Revelle comes into court and testifies, the story is completely different. And he hadn't told anybody about it with law enforcement. Then you have Dennis Carter come in here and say, yeah, I went with him May the 5th. I know it was May the 5th. Sure as I'm sitting here. I said that he didn't. But that's the gist of his words. And then what did he tell the police? Shortly after, keep in mind, this is when it's still fresh in their memory, shortly after the arrest of the defendant. What did he tell them? He said, I didn't go wrestling then. I didn't go wrestling until after the murders had happened. Days after. Just a mess. And then finally, after witness gives these confusing and conflicting stories about being wrestling or not wrestling, you have this Johnny Hamilton come in. And he testifies that, well, I'm sure it was that day. Kevin Johnson was at Search and Rescue. Keith Johnson went, and that was the only time he went. Keith Johnson says, yeah, I went wrestling one time, and some specific events happened, but I don't know when it was. Keith Johnson, I think, told the truth. He didn't have any idea when it was, but yeah, he'd been wrestling with him one time. How do we know that's not true? Not about Keith Johnson, but about that it was May the 5th. When they went wrestling, they signed this document. Keith Mercier, I hope I say that right, he came in today and testified, I only went one time. I went one time, signed the form, and it was before the murders. He's the last person that signed. He had to have signed after Keith Johnson, after Johnny Hamilton. Keith Johnson only went one time. So Keith Johnson had to have gone before the murders for Keith Mercier to have signed after him. Also on Mr. Hamilton, he says, well, I'm not going to drive 600 miles for nothing. He will drive 600 miles to testify But he won't go 3 or 4 miles from Highland Park to the police department to tell them, hey, I think you made a mistake. He doesn't tell anybody. He doesn't even tell the defense. He didn't tell anybody. Somebody goes and talks to him last Sunday, and he says, oh, yeah, I remember vividly. May the 5th. Where were we May the 5th? I ain't got the clue. The defense then moves from alibi to Mr. Bojangles. Remember Mr. Bojangles? Remember that? Is there any evidence to suggest Mr. Bojangles had anything to do with this? You have a sheet with a single negroid hair fragment. A single one. And so they pick out Mr. Bojangles to present up here as, this must be the person who did it. Well, let's think about that a minute. Well, there's blood. You know, he came in, he was kind of incoherent. Is there something to that? Could it have been Mr. Bojangles? Well, let's think about it. What about the crime scene? Picture in your mind the crime scene, and then picture in your mind Bojangles. The crime scene, not a drop of blood. Not one. Couldn't find one. The bodies were hidden. The kids' clothes were hidden. They were crammed down in the mud. The blood was washed off the bank. Had the scuff marks. Contrast that with Bojangles. Goes in there and he leaves blood all over the place. Down the hall, on the wall, on the floor, on the commode, all over the place. Do you really believe that a guy is going to go to the trouble of cleaning up the crime scene, hiding the kids' bodies, hiding their clothes, hiding any evidence of this crime that's taken place there, and then he's going to walk down through a field to Bojangles Restaurant, a public place, and leave blood all over the place? Give me a break. The defense in their opening claimed that there was going to be proof that this was Damien tunnel vision. There's no evidence of that. None. The testimony was that yes, Damien was a suspect, but he was one of a number of suspects. Just one of a number. Let's talk about these experts that were called by the defense. As the judge has instructed you, because somebody is labeled an expert, and that applies both to the experts testify on behalf of the state and experts testify on behalf of the defense, you're entitled to weigh their credibility, judge what you hear from them, and decide whether you think it's of any value or not. Let's start with Mr. Holmes. What makes Mr. Holmes an expert? He said why he had 13 years of law enforcement experience. He'd worked for Miami Police Department for 13 years, and since that time he's been a lecturer and a witness. Inspector Gitchell's had 19 years of experience. Now, but let's talk about it. Actually, you think about it. Now, Mr. Holmes is a good witness as far as presentation. But when you sit back and really think about it and analyze what he said the police didn't do anything wrong. He had some problems with the content of some of the questions and some of the responses. But as far as the police being coercive, he said the police didn't do anything wrong. In fact, if you'll think back and use your own memory, but do you remember Mr. Holmes saying, I would have done the same things myself? You remember that? Mr. Holmes' complaint is time and literature, the not. And in his testimony, he says he complains because they didn't clear these things up.
Well, as the testimony's been, and Mr. Holmes himself admitted, when you're interviewing somebody, you don't stop all of a sudden and start cross-examining them about something they said that may be wrong. The goal is to keep the person talking. And then he says in his testimony, well, they did go back later and clear up the time, but not the ligature. And actually, when he said that, if you will look and listen to these tapes, there's nothing said about how or what they're tied with until the second statement anyway. So they didn't clear it up after the first one because it wasn't in there. It was in the second one, and that was not cleared up. Now, I want to go through some of the things that Mr. Holmes said that you looked at in determining whether you've got a coerced confession or good confession. I think that's the way he put it. He says on the problems with time and the ligature, he gave a few possible explanations. You know, he had to have been doped up, or he had to have a faulty memory, or maybe just he wasn't telling the truth. Now, what do we have in this case? You know, the evidence doesn't show whether Mr. Holmes was familiar with Dr. Wilkins' examination or not. But what do we have? We've got a defendant who huffed gas, smoked pot, abused alcohol, and he found significant memory deficits. The very things that the defense's own expert said could account for these problems. He also said the most important thing, and I wrote this down, that the person sounds and looks like they're telling the truth. Yet, Mr. Holmes admitted that he had formulated his opinion before he even heard the tape of the defendant. He'd had a transcript. But how do you judge how they sound if you don't hear the tape? And he had already formulated his opinion. He gave a number of factors. It's an indication of relief. It's finally out. There's some indication of relief. Well, what was the testimony? The testimony was that after the defendant, or about the time the defendant finally admitted that he was there when these crimes occurred, that he cried. Is that not an indication of relief? Like, whew, it's over. He also says, as one of the factors, if you are wrong in a supposition in questioning the person, he will correct you. Well, let's see if you find any of that. The factors the defense's own expert says to look for. If you're wrong in a supposition, he will correct you. On page 3 of the transcript, Inspector Gitchell asked, whose car were y'all in? Suggestible question, isn't it? Leading question, isn't it? Well, does he buy in? Does the defendant buy into the suggestion? Does he go along with the supposition? No. He says, we walked. He corrects him. No, we didn't go in a car. We walked. Then, on page 10 of the transcript, if you're wrong in a supposition, he will correct you. Detective Ridge says, did they take like one picture of one boy? The supposition is there's one picture of one boy. Did he go along and agree with this supposition? It's a suggestible leading question, right? No. He says they were in a group. He corrects them. No, it was not one boy in one picture. The boys were in a group. Then on page 18,
Detective Ridge, besides just playing, the little boys, had they been in the water? Did they get into the water with you all? The supposition was that the little boys had got into the water. Was that an incorrect supposition? Did he correct him? He says, no, they did not get into the water with us. He corrects him. Does the very thing that the defense's own expert says that you would do when you're confessing, and not a coerced confession. He then says that in a confession, uncoerced, that you have, in there they relate conversations with co-defendants. Do you have that in this case? Well, the proof was that before the tape, he admitted that he was present, the tape was started, that there was a telephone call from Jason Baldwin to this defendant. And in this phone call, Damien is in the background saying something to the effect of, tell him we're going to get some girls. And he says, hey, I know what's going on. Do you think if the guy's going to make up something, he's going to make up dialogue of something like that? Or would Mr. Alshay say that they manipulated him into saying that? On page 3, again, remember one of the things the defense's own expert says is you'll have conversations between the co-defendants. The defendant on page 3 says, he called me, asked me could I go to West Memphis with him. I told him no, I had to work and stuff. And then he told me he had to go to West Memphis. So him and Damien went. Conversations between the co-defendants. On page 6, conversations. Says he took off running, went home. Then they called me, asked me how come I didn't stay. I told them I just couldn't. Again, the very things that the defense's expert says that you find in an uncoerced confession. And then page 12, you got the telephone call where he says, we done it. What are we going to do if somebody saw us? All conversations with co-defendants. He then says, another factor is that there's something that corroborates the confession. Now, is there anything in this case that corroborates the confession? Anything at all? Think about it. Number 1, Tabitha Hollingsworth. She testifies, and her testimony was not challenged one iota. She testifies that her mother and her rest of her family are going to pick up grandmother, aunt, whatever, some relation. And on the way there, between or about Blue Beacon Truck Wash, you know, the woods are just to the side. Y'all know all about the crime scene. That they see, walking along the service road, Damien and his girlfriend, Dominique. And do you remember how she described the clothing? Said they were muddy. She also said that they were wearing black and that Dominique had holes in her knees. You remember that? If you got it in your notes, refer back. Think back about that. Holes in the knees. Now, what did the defendant say about what Jason was wearing? All black, one of these shirts with the skull on it. And it's in the tape about what he's wearing. And how does he describe the pants that he's wearing? He said he had holes in the knees. At night, along the service road, Dominique's got red hair. Jason Baldwin, slightly built, long hair, pants with holes in the knees.
That's one thing that corroborates the confession. You've got Damien. You've got him at the scene by Tabitha's testimony, and you also have the testimony of Lisa Sakavicius, that's the right pronunciation, about the fibers. The fibers that were taken from one of the victims' clothing that were consistent with having come from this one shirt out of Damien's house. The testimony was that she checked fibers at the victims' houses, she checked fibers at Jason's, Damien's, the defendant's. And out of all that, one article of clothing, the fibers matched. Sure, they can say, well, those fibers, as the witness said, well, it could have come from a similar type garment from the same batch of dye. But out of all those houses, you get one garment that matches. Then, on Jason, again, you have a fiber that matches. The only match out of all the clothing in all those houses. The only match. Is that a coincidence? Is it a coincidence that the defendant describes Jason as having pants with holes in his knees and wearing all black? And then Tabitha saying, well, I see Damien and Dominique, his girlfriend, and just so happens she's got holes in her knees. Is that a coincidence? Then we get to something that corroborates it, which is another thing Mr. Holmes says about some inconsequential matter. I think the way he described it was somebody walking by or some conversation or something. Do you remember what the defendant said in his statement about what he did with his tennis shoes and what kind of tennis shoes they were? He said that he gave them to a guy named Buddy Lucas. And he describes in his statement that they were white and blue Adidas. Detective Ridge testified that he went to Buddy Lucas's, and lo and behold, what did he get from Buddy Lucas? The white and blue Adidas. Is that a coincidence? I think not. Then you get to further corroboration, the injuries. When in discussing, and listen, you have the right to listen to those tapes as many times as y'all want to. Listen to those tapes. Don't rely on what I say they say, or what Mr. Stidham or Mr. Crow says, or what Mr. Davis says. You go back there and listen to those tapes. Listen for the inflection in the voice. Listen for the yawns to show the tremendous pressure he was under in this interview. But when you listen to it, what you're going to find is they ask him, says something about a boy, and where was the person cut? He says, in the face. Now, in all of this stuff that Mr. Stidham put on about this knowledge, the stuff in the paper about that they were all sexually mutilated and that kind of thing, nothing in there about a boy being cut in the face. They were beat up real bad, but nothing in there about somebody being cut in the face. He says, yes, one of them was cut in the face. And then they say, well, where was another boy cut? At the bottom. Ends up, he says, in the area of the groin area. Now, is all of that just coincidence that he says that? Or is it, as Mr. Offshay says, that somehow these devious officers manipulated this defendant into saying things that weren't true? You've also got
another factor. That's the ears. The defendant tells about the kids being grabbed by their ears. And you heard the medical examiner's testimony. Whatever the purpose for grabbing the ears, this defendant, in his statement, says they were grabbed by their ears. And if you'll look at that, you'll see that's exactly what he says. And Inspector Gitchell testified that before he actually said it, he was even demonstrating it. And what do we have from the medical examiner? You've got damage to his ears, bruised ears, consistent with having been grabbed. You've got 3 guys supposed to be involved in this. The defendant, Damien and Jason. How many weapons did the medical examiner say that he could put a minimum number on? 3. At least 2 club-type weapons. I mean, you don't have to be an expert to look at these photographs and know that those injuries were not caused by similar type things. It's obvious that these were caused by a smaller object, these by a larger object. And then you have the knife. Is it a coincidence again that we've got 3 weapons? He also says that, and this is in a sense corroboration of what he says in his statement. Mr. Holmes says that it's natural for a person to try to lessen their involvement. Out of all 3 of these kids, for the defendant to associate with himself with, as far as one that he dealt with, which one did he pick? He picked Michael Moore, right? Which of the 3 boys didn't have any torture type or mutilation to them? Michael Moore. Is that coincidence? Or did the police somehow say, well, this would be a good scenario here. We'll get him to admit to it, but we'll only have him involved with one of them that wouldn't hurt too bad. No. It's not coincidence. It's not an accident. It's not a guess. It's telling what he knew, despite his faulty memory and his gas huffing and alcohol abuse. And while we're talking about that, if you recall Dr. Rickert testifying about the effects of the faulty memory and the things you remember and won't remember, the things that you remember are the significant things. This was over a month later. Or, excuse me, it wasn't over. It was about a month later. Which details is he right on? The most traumatic, terrible events. Which ones is he wrong on? 2 things, time and rope. Are those the significant things that a person with memory deficits is going to remember and have branded in their mind? I think not. In regard to time, and it was somewhat pointed out this morning in Inspector Gitchell's testimony, there's an interesting statement in here by the defendant. He's saying this noon stuff and 9 o'clock in the morning and all that. On page 12, and listen to this. When you get back there, again, make sure that you ask to listen to the tape and get it to this spot. And you look and you'll see that nobody has said anything about, hey, it happened at night or anything like that. And you're going to hear Jessie say, well, after all of this stuff happened that night, that they done it, I went home about noon. Absolutely makes no sense at all, but you'll hear those words come out of his mouth. Is it because we've got somebody that doesn't have any concept of noon? It's not words put in his mouth. That's not anything from a question that was asked to him. Those are his words. Well, after all of this stuff happened that night, was that some kind of a slip? Why did he say that? He's the one who first says about it happening that night. Then we get to Dr. Wilkins. He described the defendant as a gas huffer, heavy alcohol user, pot smoker. And then you see the defendant throughout this trial. And you ask yourself, and you listen to these experts and you say, who's being deceptive? Is it Inspector Gitchell and Detective Ridge when they say, look, we just talked to the guy, we let him talk, we took his information, and when we found out and when we realized that he was identifying injuries to particular people that only a person that was there and involved knew, we knew we had our man. Now, are they the ones being deceptive? Who's being deceptive? This is the person that was there on May the 5th. The bright eyes, the clear eyes, that is the person that was there on May the 5th. Not the person that you've been observing, allowed to observe throughout this trial. Who's being deceptive in this case? Dr. Wilkins claims that this defendant is suggestible. Remember when he was asked, well, did you do some kind of test? Or was there any test that showed that? There's no basis for his opinion other than his general conclusion that he's suggestible. And remember what Dr. Rickert said about being suggestible? And how you'd need to know whether the person had a memory problem because that could affect whether they're being suggested to or they just don't remember. Remember that? Dr. Wilkins himself testified that this defendant had significant memory deficits. Then we get to Mr. Offshay, or Dr. Offshay, as whichever one you prefer. But Dr. Offshay, or Mr. Offshay, he can't treat a broken arm. He can't treat your mind. He's not a licensed psychologist. You can't be licensed as a social psychologist. He's a professor and a professional witness. And I will say this. As Mr. Davis said, he's earned our respect. He is an expert witness. An expert at testifying. You observed him. Do you believe that he would have even agreed that Mr. Davis's shirt is white if he had asked him? He probably would have wanted to explain his answer. Just because you hold yourself out as an expert in something doesn't make you an expert. Just because you come in with a lot of degrees and a Pulitzer Prize, but as you heard Dr. Rickert, it may as well have been the Heisman Trophy. The Pulitzer Prize has no relevance to scientific testimony. None. He's from Berkeley, California, and he came and put on a show. And it was, from my standpoint, pretty entertaining. May not have been too entertaining for Brent, but it was pretty entertaining
to watch this expert at testifying testify. Last year, he earned $40,000 just going around testifying. And how many times could he recall ever testifying on behalf of the prosecution? Not one. And you might say, well, but the prosecution obviously wouldn't want him to come up here and testify. Obviously wouldn't want him to come up and testify that it's a coerced confession. But, why, he says 40% of the time that he looks at these things that he finds are not coerced. Well, don't you think out of that 40% or whatever percent he said, that one time the prosecution would have said, well, they're challenging the voluntariness of the confession. Would you come testify for us? No, he only testifies for the defense. Of course, he claims that, he doesn't make much money, but he made $40,000. Charges $300 an hour, but he's never gotten it. I mean, isn't that what he said? Says he charges $300 an hour, but had never been paid that much. I think he values himself more than what he's really worth. But let's talk about the substance. And I've talked a lot about his qualifications, and I think y'all are acutely aware of what the proof is about that. But what he boiled down his opinion to was his problem was about the same problem that Mr. Holmes said. Just had a problem with that time. Of course, Mr. Holmes says that the time thing was cleared up in the second interview. But Mr. Alshey spends all his time talking about the time problem. Now, I want you to think, and you use your own memory. Don't rely on what I say. Use your own memory. What scientific basis did he give for concluding that any of that statement was coerced? He didn't give you any. He didn't. It wasn't there. He just said it's coerced because I've reviewed this just like you could review the transcripts and listen to the tapes and say, there's a problem with time. You need to pay a guy $300 an hour to look and see there's a problem with time? And I don't mean to make light of it, because it's a serious situation. It's a serious problem. But the defendant is the first one who mentions it happening at night. And then he reverts talking about it being in the morning. Why he did that? Why he said that? I don't know. The testimony's been he's got significant memory problems, been huffing gas. I don't know. But when you analyze the way he talks in that tape, and you analyze what he said, you find he's not being coerced or manipulated. He's telling what he thinks is the truth about the time. And the most significant details of the crime he gets right. He says the problem is the suggestible questions. Now, if you've got a person, and whether he determined that this defendant was a suggestible person or not, I never was clear on. I never heard him say anything about that. Now, Dr. Wilkins did, but he didn't have any basis for it. Couldn't give you any basis for it. But he says the problem is the suggestible question, which to me sounds like a leading question. Kind of like, lawyers always jump up objecting if it's a leading question. Sounds about the same. Well, is a leading question coercive? Well, if the leading or suggestible question is coercive, you just say, well, that's not right. Like, whose car were y'all in? No, we weren't in a car. We walked. That's pretty easy to do. And the defendant did it. But if those questions are suggestible and the officers are manipulating this defendant, don't you think that he would be agreeing with them when they ask him a question that's leading or suggesting it? And let's go through this. And let's look at these suggestible questions. Start at page 4. Detective Ridge, what occurred while you were there? Any manipulation, suggestion, or leading in that question? What occurred while you were there? And he answers. He tells them, I saw Damien hit the boy real bad. Anything suggestible or leading about that? No. Page 6. Have they got their clothes on when you saw them tied? That's the leading question. Suggests that they had their clothes on. He says, no. They had them off. You know, from the photographs, it's obvious that they couldn't have been tied with their clothes on. They had to have been tied after their clothes were off. They couldn't have gotten their clothes off. So there, he doesn't buy into the suggestion, if you want to call it that, or the leading. Page 7. Where was he cut at? Or where did he cut him at? He was cutting him in the face. Anything that would suggest that he was being cut in the face. Now, they said, well, he might have been pointing to his face. Ladies and gentlemen, there's not one iota of evidence that that took place. Not one. And you remember your oath. You can't base it on speculation. You can't base it on conjecture. It's got to be on evidence. And there's not any evidence that that took place. Where was he cut at after he talks about cutting him in the face? At the bottom. Well, they might say, well, he was... After there's a reference to the groin area, and he says, well, they led him into saying the groin area. Well, the officer testified that he was, when he said bottom, he was pointing at the groin area. But even if you want to say bottom, look at the photographs of Chris Byers in his bottom and see if it's not cut. And he asked, which boy was that? Talking about the boy castrated. That boy right there. And he points at this boy. There is no evidence that there was any suggestion made to this defendant about which one of these pictures to select. And, you know, to believe that they did, there's no evidence of it. So you couldn't find that. But let's just say that you said, well, they did. You would have to conclude that these officers were so dishonest and twisted that they would pin it on an innocent person, a person they knew to be innocent. And on page 10, has he ever had sex with them before? Talking about Damien and the little boys. Doesn't that suggest that the officers think that maybe Damien had sex with them before? And under Alshay's theory, the defendant should have said yes, and then tried to figure out what they wanted him to say next. He says no. No, he's been watching them. No, he hadn't been having sex with them. He's been watching them. In page 11, talking about the pictures. And this next thing is throughout this. It has these same three boys in it. Yes. And then Detective Ridge says, you're certain of that? Ask them that on a number of occasions after they've given a response that would be a response that's consistent with the facts. You're certain of that. Now, what did Alshay, what did he say when Mr. Davis asked him about that? You're certain of that. What does that mean? Do you think they're trying to lead him when they say that? Aren't they questioning his answer when they say that? Oh, he says that's to reinforce it.
to reinforce it. These officers are skillfully manipulating the defendant, and this is to reinforce it. Well, when we get over here, in the second interview, when we're clearing things up, he gets over here, and you know that the medical examiner testified about the injury to Stevie Branch's penis, what he called a suck mark or whatever you want to call it. And there are some little bruises across the penis that you could conclude are teeth marks. You look at the bruises. And the officer goes in there and he asked, did anyone maybe suck theirs or something? And Jesse says, not that. I didn't see nothing. Neither one of them do that. Again, the question's leading or suggestible or whatever you want to call it. Does he buy into it? No. And then Inspector Gitchell says, you didn't see that. Jesse says, Gitchell again says, okay, did they pinch their penis in any way? Or were rough with it or anything like that? Jesse, I didn't see nothing like that, not rough with them. I just seen, and Gitchell says, you didn't see anyone go down on the boys the third or fourth time. Gitchell, are you sure? Is Inspector Gitchell now reinforcing an answer that's inconsistent with the facts? It's obvious the defendant just didn't see this incident. Now, when it works to the defense's advantage, all she says, if he asks, you're certain of that, well, that means you're reinforcing it. Skillfully reinforcing it. But when it's the other way, what is it? What is it? We're just asking questions. They're questioning, are you sure? When they ask, are you sure that Chris Byers is the one that was castrated? Are you sure? It's giving him an opportunity to say something else. And he doesn't take that opportunity then, and he doesn't take it when they're asking him about this injury to the penis. In fact, this shows directly to the contrary of what Dr. Wilkins and Offshay say about the suggestibility. It shows that he is completely able to resist suggestion. There are a number of other times in there when similar type questions are asked, and I'm not going to go through every one of them. You can find them for yourself where there are apparently leading or suggestible questions that he doesn't buy into. He doesn't go along with. Then in the second tape, in referring to time, when he talks about 5 or 6, 7 or 8, Inspector Gitchell is questioning about that time. And finally he says it was starting to get dark. He abandons trying to refer to it by time because he has no concept of time. And he says it's starting to get dark. Page 4. Did you ever see the boys in the water? Suggestible, leading that yes, they were in the water. Jesse says, yeah, down by the water. He doesn't buy into it. Page 5. Did you see the Moore boy? Was he raped? Certainly suggests that he was, right? Leading question. The answer? No. Finally, in talking about the boys being sexually abused, Inspector Gitchell says, so they both did it to all 3 of the boys. Jesse, Just them two, as far as I know. The purpose of all this that I've gone through, and I hope I hadn't bored y'all too much, but Mr. Offshay testified and went over and over things that he claimed showed how suggestible this defendant was and how the police were manipulating this defendant. These are just a few examples throughout this transcript where what you might call leading questions, and by no means are all the questions leading, but some of the questions you might consider leading, where the defendant, as Mr. Holmes said, he'll straighten you out. And that's what he did. He didn't just cave in and have his will overborne. This expert, when it's the way he wants it to be, then it's police manipulation. But if it's to the contrary, he ignores it. And the best example of that is about him saying that, "Are you certain?" reinforces it. When Inspector Gitchell asked, "Are you certain?" on a question that he was stating that was inconsistent with the facts. Can't have it both ways. It's either reinforcement or it's not. And then, and we went through this. Now, why this very skillful expert testifier did this, I don't know. But he testified that night was not mentioned until page 18 when Detective Ridge said, "The night you were in these woods." And if you'll remember, back on page 12, and you'll have that with you back there, the transcript and the tape, it was the defendant himself who first brought up night. Now, why Offshay tried to pass off to y'all that the police had introduced night, I don't know. Was he wrong? Just wrong? Mistaken? Doesn't have a grasp of the facts? Or was he misrepresenting to you? He then testified in regard to the follow-up tape that nowhere in the record does the defendant say 7 or 8 until Inspector Gitchell mentioned 7 or 8. Inspector Gitchell testified and explained where he got 7 or 8. And it was from the defendant's mouth. And then on page 3, again, why he did this, I don't know. All she tells you that where the transcript shows that Detective Ridge said 9 o'clock in the morning, while the transcript's wrong. That was Jessie that said that, according to Offshay. Listen to that tape. I don't believe you'll have any trouble distinguishing between Detective Ridge's voice and the defendant's voice. And it's clearly Detective Ridge saying 9 o'clock in the morning. Now, if these officers are going to skillfully manipulate this defendant after he says it was in the morning, why would he say 9 o'clock in the morning? Finally, in regard to Mr. Offshay, this is the same man that, despite all these flowery explanations for why this occurred, it's the same man who, in the state of Washington, testified that a man had given a coerced confession, a wrong, untrue confession, when his 2, not minor daughters, or mentally handicapped daughters, or anybody else, his 2 adult daughters, said that he had molested them. His wife said that it happened, and he said that it happened, and confessed to it, pled guilty, and not until the expert testifier goes and talks to him does he suddenly say, this is after more than 5 months of maintaining this guilt, that I'm not guilty. Were all these people skillfully manipulated and coerced into saying these things? Well, the state of Washington and their courts thought not and discounted his opinion. The bottom line in this case is these officers' integrity. Inspector Gitchell and Detective Ridge, there is absolutely not one iota of evidence that they have told anything other than the truth in this courtroom. Anything other than the truth about what happened there, there is no evidence of that. There's no evidence of coercion. There's no evidence of them yelling at them. As Inspector Gitchell said, sometime you have to do that. In this case, it was not necessary. There's no evidence of any form of coercion. What's the defense? Are they saying that the defendant was brainwashed? Is that what they're saying? This defendant knew facts that nobody else knew. Now, when you look at these documents that the defense introduced, I believe it's going to be clear that he was given information nobody else knew. The newspaper, what they printed was that all the boys had been sexually mutilated. Well, if that's the information he had, why didn't he say, well, all three of them were cut in that place instead of one, and pick out the right one? Got a little report here from interview with some guy named Kelly. Rumors. Castrated and mutilated, beaten to death. Did it say one was castrated? Mutilated? Anything about cuts in the face? No. And then another one. In response to the question 9, which is, how do you think they died? Pointed to penis, said heard cut off. Heard it was cut off, and they were beat up. He didn't say it was cut off of 1 or 2 or 3. There's no evidence that who was cut or how many was cut was common knowledge. You've got injuries to the ears nobody knew about. The defendant described the way they would have happened. You've got injury to the genital area where he identified the specific person. Yes, there's information that all of them had that, and that was not true. That was wrong information. And he picks out the one person who it was done to. Injuries to the face were not common knowledge. Finally, we get to the Bojangles defense, which we've already talked about briefly. And use your common sense. The judge says you can take it back to the court, to the jury room with you. Is somebody that's going to go to all the trouble that these defendants went to in cleaning up that scene, are they going to then, or he going to then go into a public place and leave blood all over the place? In this system, we all have duties. Barbara's duty, and even though she's not doing her little typing thing, she's still taking everything down by tape recorder. In the courtroom, that's her job, is to take down everything that's said. The sheriff's office, to act as bailiff, provide security, and they've done their duty. Inspector Gitchell and his men investigated this crime to the very best of their ability. And keep in mind what the medical people said. Let me digress a minute. This was a clean scene. It's not like being in a house where the evidence is contained. This is outside in the woods, but yet not a drop of blood. They might say, well, it must have happened somewhere else, and they carried him in. There's no trail of blood leading out there either. And this guy going in Bojangles leaves blood dripping all over the place. Not any blood out there because it had been wiped down. And you've got the pictures, and you can see in the pictures the condition of that bank where it had been cleaned off. You've got the most destructive thing to evidence that you can have. Water. You got the bicycles in water. You got the kids in water. You got their clothes in water. And despite all of those problems, the forensic people at the crime laboratory were able to obtain fibers that matched both Damian Eccles and Jason Baldwin, despite all those problems. And they also found, and this was somewhat confusing, the testimony, at least it was for me. Some of y'all may be scientists or science people, but the testimony from Dr. or Mr. DeGuglielmo about the DNA. Now, if you'll recall, Kermit Channel from the crime lab said that in his test on the little boy's pants that he ran screening tests. He ran one screening test and it came back positive for semen. He ran a second screening test, positive for semen. He looked under a microscope and the pants were all muddy and everything, and he couldn't see any sperm, but he had these two positive tests for semen. So he sent those cuttings from the pants to Genetic Design in North Carolina. And that was the man from North Carolina. And what did he tell you? When you boil it all down, if I can boil it down, he tells you that in his opinion, the DNA that he found from those cuttings was from sperm. Did he see any sperm? No. Because he doesn't look at things under the microscope. His are DNA tests. He said, they asked him, Mr. Stidham said, are you saying positively that there's sperm there? And he said, well, no, you can never say positively unless you look under a microscope and are able to see it. But if I had done that, it would have used up part of the sample. And we were trying to preserve the sample. But with his opinion, with the test that he ran, if you'll remember, there's the epithelial, what he called fraction, and the male or sperm fraction. Remember the way he was describing how you split out the two when you've got more than one suspect and you split it out so you'll be able to divide them up? The epithelial fraction is the non-male fraction. If it's something other than sperm, it's going to show up in that, like blood. Well, when he got the DNA test back on the epithelial side, nothing. No DNA. On the male fraction, the sperm fraction, it was positive for DNA. And he stated that in his opinion, that this indicated the presence of sperm on those pants. So despite, not enough to connect to this defendant, but it wasn't enough to connect to anybody. It's not as if you had something that just didn't connect to this defendant. It wasn't enough to connect to anybody because there's just not enough of a sample. So despite this clean crime scene, the forensic people at the lab and through the work of the police department, they were able to come up with that corroborating factor, the fibers that matched Damien and Jason. And then you got the judge, and back to the duties. Judge Burnett's job is to keep us all in line, and you've seen probably more objections and approaches the bench than you ever want to see. But those things, as Mr. Davis pointed out to you in voir dire, sometimes they're necessary, and we have to do those things. But his job is to be the judge of the law and to give you the law that you're to follow. Mr. Stidham and Mr. Crow, it's their job to represent this defendant. And they've done that. It's Mr. Davis and my job to present to you the state's case, and we've done that. And now we're about to enter the phase where really the job becomes yours, the entire job becomes yours, to judge whether or not, based solely and exclusively on the evidence that you've got before you, whether the state has met its burden of proving this defendant guilty of 3 counts of capital murder. I submit to you that the state has met its burden of proof. I submit to you that you should go back, deliberate, take your time. This is not something to rush through. Listen to those tapes and then return your verdict of guilty. Thank you.
On trial, there have been a lot of objections and there have been a lot of approaches to the bench, and I also thank you for that. During the prosecution's closing argument, I got a little confused, and for a minute there I actually thought Dr. Richard Offshay was on trial instead of Jessie Misskelley. I think there's a reason for that, ladies and gentlemen of the jury, and I think the reason is clear. The prosecutor spent most of his time talking about our defense, Mr. Holmes, and Dr. Offshay. The reason for that is because they don't have a case against Jesse Lloyd Misskelley Jr. In order for you to find that Jesse Lloyd Misskelley Jr. is guilty of 3 counts of capital murder, you must find him guilty beyond a reasonable doubt. And we talked about that in Vaughan, and I want to talk about it again. And if we make it through this with this thing without falling, it'll be a miracle. As we talked about in Vaughan, ladies and gentlemen, there are 3 legally recognized burdens of proof in the law. The first one is by preponderance of the evidence. That's the lowest standard. The middle standard is clear and convincing evidence. That means you have to have evidence which is clear and convincing. And then there's the top standard, beyond a reasonable doubt. The highest standard recognized in the law. For you to find Jesse Lloyd Misskelley Jr. guilty, you must find that the state proved its case beyond a reasonable doubt. Ladies and gentlemen of the jury, we would submit to you that there is a reasonable doubt about the defendant's guilt. In fact, we would submit to you that there's many, many reasonable doubts. And that's what I'd like to go over with you in closing, is these reasonable doubts. And I want to talk to you about each and every one of them. The first area of reasonable doubt is Jesse's story that he gave the police. What evidence has the state introduced against Jesse in this trial? His statements. That's all they got. There's nothing else. This wild story that he told the police on June the 3rd, 1993. In this story, Jesse says that Jason called him at 9 p.m. on May the 4th. He also says that Jason Baldwin called him at 9 a.m. on May the 5th. That can't be true. Jesse wasn't home. He spent the night with Josh Darby on May the 4th. He went roofing at 9 a.m. the next morning. And that was testified by 2 witnesses. Josh Darby doesn't have a telephone. How could he have gotten these phone calls? The next reasonable doubt, ladies and gentlemen of the jury, is that the victims were sodomized. Jesse told the police that these little boys were raped. There's no evidence of that. The medical examiner sat right there in that chair and told you that there was no evidence of physical trauma to those little boys suggestive of the fact that they'd been sodomized. The next reasonable doubt, Jesse in this story tells the police, well, I was up there by the service road when this was happening. Do you remember where the service road is on the diagram of the crime scene? About 450 feet through dense vegetation. It was impossible. A witness testified that it's almost impossible to see through there now in January. Imagine what it would be like in May when you have all that foliage. It's not possible. Probably the biggest reasonable doubt that we've heard during the course of this trial is that Jesse says the murders took place at noon. Everyone agrees that that's not true. It can't be true. The victims were in school all day. Jason Baldwin was in school that day. And Jesse was roofing till past noon. So we know that this could not have happened. The next reasonable doubt, Jessie says that he went to West Memphis with Damien and Jason at 9 a.m. on May the 5th. Again, we know that's not the case. Jason was in school all day, and Jessie was roofing with Ricky Deese and Josh Darby. We know that that's not true. It can't be true. I'm going to try it this way. Another one of the major reasonable doubts is the brown rope. The victims were not tied up with a brown rope. Jessie tells Gitchell they were tied up with a brown rope. It just didn't happen. Everyone knows that the victims were tied with shoestrings. Another reasonable doubt, ladies and gentlemen of the jury. Jessie says that Damien choked Chris Byers with a big old stick. The medical examiner says that didn't happen. There's no evidence on the body to suggest that Chris Byers was choked or that any of the victims were choked. It just didn't happen. The prosecution wants you to forget about these major impossibilities. They want you to believe only the things that Jessie may have gotten right. They want you to forget about all these big reasonable doubts. That's why we're here today, ladies and gentlemen of the jury, to talk about reasonable doubts. The next area of reasonable doubt deals with Jessie's alibi. The prosecution would have you believe that Jessie somehow has a mystical, magical time machine which enables him to be in two places at one time. He can't do that. We can't do that. Nobody can do that. You can't be in two places at one time. May the 5th, 1993. The prosecution would have you believe that that's just like any other day. No special reason to remember what you were doing that day. Well, that may be true for people who didn't live in West Memphis. Or excuse me, for people who didn't live in West Memphis. But for people who did, people who lived in Highland Trailer Park and other parts of the city, May 5th was an important day. There are several reasons why it was an important day. And before we talk about this, I would ask each and every one of you to think about how is it that you remember things? How do you remember events and dates? You go back and you look at calendars, you look at birthdays, you look at events, and you go back and try to tie those time references together. That's common sense. The dollar incident happened on May the 5th. Everyone in Highland Trailer Park was outside looking at the incident. Cody Romero was pulled off the bicycle by the head of his hair. Everyone was out there and seen that. The police were out there. The police testified that they were there. The police logs show that they were there. Everyone was outside. Kevin Johnson on the search and rescue squad. He was at a meeting that night. He remembers that night. He testified that he remembers that night. He told you that he was supposed to go wrestling with his brother. He invited his brother Keith Johnson to go that night. But he went to a search and rescue meeting, and at that search and rescue meeting, he heard about the boys missing. He didn't know whether they were going to have to go out and look that night. He didn't go wrestling. Keith Johnson only went wrestling that one night, and that's the night that his brother was at the search and rescue meeting. Also, ladies and gentlemen of the jury, Jessie Sr. was at DWI school that night. You've seen the receipt, evidencing the fact that he was there. You've seen the roll sheet where he was present at the meeting. Also, the boys were missing that night. Everyone in town knew that, especially folks who were on the search and rescue squad. The next day, the bodies were discovered. And that was on not only the local news, but the national news covered that. Everybody in West Memphis can remember that day. Everybody. Not just people in Highland Trailer Park. Not just people who wear yellow ribbons. Everyone can remember that. May the 5th, 1993. I prepared a timeline to demonstrate to you the aspects of Jesse's alibi all day. At 9 a.m., Jesse is roofing with Josh Darby and Ricky Deese. At 1 p.m., Ricky Deese drops Jesse off at home. He's in the trailer park at 1 o'clock. Not at Robin Hood Hills, witnessing 3 boys getting killed at noon. 2:30 p.m., Jesse begins babysitting for Stephanie Dollar. 3:30 p.m., Susie Brewer comes home, goes to the trailer park. She joins Jesse at Stephanie's and helps him babysit the children. 4 to 6 p.m., many of the people that testified during the course of the trial told you that they seen Jesse between the hours of 4 and 6 p.m. in Highland Trailer Park. (6:15 p.m.), Jim McNeese has to close down Jim's repair shop because Jesse Sr. is at DWI school. He testified that at 6 o'clock or about that time, he closed the shop. He went home, and at 6:15 p.m., Jim McNeese sees little Jesse and Dennis Carter out in the street. He talks to them, and they talk about wrestling. 6:30 to 7 p.m., again, is the Dollar incident. There was lots of people outside watching and trying to figure out what was happening. The police were there. Everybody's outside wondering what's going on. Lewis Hoggard, the trucker, you've seen his truck log. He told you when he was in town, May the 5th. He sees Jesse. Charles Ashley, he sees Jesse. Susie Brewer, Stephanie Dollar, Christy Jones, Dennis Carter. These people are with Jesse at Highland Trailer Park. (7:15 p.m., Jesse Sr. comes home from DWI school. The police are leaving the trailer park. He's afraid because he's driving on a suspended license. That's how he can remember. He quickly goes home so he doesn't get caught by the police for driving on a suspended license. He sees Jesse Jr. at the trailer. At about 7:30 p.m., little Jessie Misskelley leaves for Dias with these individuals. Freddie Revelle, who testified, Bill Cox, who didn't testify, Roger Jones, Dennis Carter, and Johnny Hamilton, who we were able to find right before the trial, before the defense started presenting its case. All these people, ladies and gentlemen of the jury, testified to you under oath that Jessie Misskelley was with them in another county about 40 miles away from West Memphis on May the 5th at the time that these little boys are being murdered. (8 p.m., Jesse and the other wrestlers meet Keith Johnson at the Exxon station at the junction of Highway 63 and Interstate 55. They pick up Keith, they go on to Diaz, and at about 11:30, Jesse and the others arrive back at Highland Trailer Park. From 11:30 to midnight, little Jesse spends time with Roger Jones and Jennifer Roberts at their trailer. That accounts for him the entire day. The entire day. You're going to have to ask for a timeout and switch pads. The next area of reasonable doubt, ladies and gentlemen of the jury, is a very, very important one. No physical evidence linking Mr. Misskelley to the crime scene or to these homicides. None. Not even a little bit. None. There's no footprints on the blue Adidas shoes or any other shoes they looked at. no fingerprints, no hairs. Lisa Sakavicius, that's the best I can do, and I'm sorry, testified that she'd examined hundreds of hairs, none of which matched little Jessie Misskelley. No fibers matched Mr. Misskelley. None. No physical evidence. There is one item of physical evidence which the prosecution would have you just bypass and ask you to not consider because it's not very important and it's not logical. Well, I would submit to you, ladies and gentlemen of the jury, that when 3 little boys are murdered at approximately the same time that a gentleman stumbles into a fast food restaurant minutes from the crime scene, covered with blood and covered with mud, and the police aren't even interested enough to come in the store and check it out till the next day and take blood samples? Were the blood samples ever submitted to the crime lab? Were the sunglasses ever submitted to the crime lab? Who knows? I call that a reasonable doubt. On Christopher Byers, the boy who was mutilated, the negroid hair was found on the sheet covering his body. Is that a coincidence, as the prosecution would have you believe? I don't think so. I call it a reasonable doubt. The next area of reasonable doubt, ladies and gentlemen of the jury, is this cult business. Officer Ridge testified that he couldn't confirm any of the people on Jessie's list of cult members. None. Detective Ridge also testified that there were no cult artifacts at the crime scene, that there were no cult artifacts at Turtle Twist, where this alleged cult meeting was supposedly taking place. There's no evidence that this is a cult homicide. No evidence. The next area of reasonable doubt, ladies and gentlemen of the jury, is the fact that little Jessie Misskelley has a mental handicap. He has a low IQ, he has low self-esteem, he's very suggestible, he's codependent. He feels the need to conform to authority figures. And that's why some of the most compelling testimony that came out of this witness chair was from 2 expert witnesses, Mr. Holmes and Dr. Offshay. The most compelling testimony came from those 2 witnesses about these very ideas, and more specifically about the profile of one who falsely confesses to something they didn't do. Mr. Holmes, who doesn't have 13 years of experience, 39 years of experience with the Miami Police Department, lecturing to the FBI, the CIA. This gentleman worked on John F. Kennedy's assassination, Martin Luther King's assassination, Watergate, the Boston Strangler case, the Hampton case in Louisiana. 39 years of experience. And what did he tell you? The profile of a false confessor is someone with a low IQ and a weak personality. He also told you that there were several problems with Jessie's statement. A, there's no corroboration. Jessie Misskelley didn't tell the police anything that they didn't already know. Nothing. There's no narrative in the statement. The prosecutor has asked you to go back to the jury room and listen to the tape. I want you to do that too. And when you're listening to the tape, ask yourself this question. Does this sound like a kid who is telling you about something that he's seen, or is it telling you something about that he made up, or that was suggested to him? There's no narrative in the statement. Every time the police officers ask him to elaborate about a detail, he says, well, they were doing this and stuff. And they were doing this and stuff. Then we did this and stuff. Does that sound like someone who witnessed 3 homicides telling about it? There's no narrative. Mr. Holmes also testified that Mr. Misskelley was wrong on too many points. And we talked about those earlier. Mr. Holmes concentrated on 2 of the big ones, time and ligatures. two very, very important things about the crime that Jessie Misskelley got wrong. Mr. Holmes also testified that the officers were very leading and very suggestive. They led him through this entire tape statement. And ladies and gentlemen of the jury, we don't know what happened before they turned the tape recorder on. They didn't videotape it. The officers didn't take notes on all the questions. They testified to that. They even testified they couldn't remember some of the things they asked him. How do we know what really happened? And that's when we get to Dr. Offset. Dr. Offset is a doctor. He's not a medical doctor, but he is a doctor. And I would submit to you, ladies and gentlemen, that his testimony was riveting. His testimony was very, very helpful in trying to establish what happened in this interrogation. Dr. Offset also testified that the profile of a false confessor is someone with a low IQ and someone who has low self-esteem. His expert opinion, ladies and gentlemen of the jury, this is what he told you, that the West Memphis Police Department used coercive psychological tactics to get a statement from Jessie Misskelley. The police were suggestive and they led Jessie through the entire statement. When you listen to the statement, when you read about the statement, think again about the narrative and think about the way these officers led him through the entire statement. The way they suggested things to him through the entire statement. Ladies and gentlemen of the jury, what I'm about to tell you is the most important thing that you will hear throughout the course of this trial. A very learned judge in the state of Florida once said in one of her opinions, she said that the killing of one human being by another is a most heinous act, only exceeded by the killing of an innocent man by the state. Ladies and gentlemen of the jury, my client, little Jessie Misskelley, is an innocent man. He's innocent. And I would ask you to go back to that jury room and bring back a verdict that rings of justice, truth and justice. And I would ask you to bring back a verdict that you can live with for the rest of your life. Thank you.
Take a stretch break, about 2 minutes in place. Okay, just stand up and stretch, be fine while.
You know, at this point, we're all tired. We spent weeks in preparing this case. While a lot of times while y'all have been out in the halls, we've been in here at each other's throat. And we're all tired, and we all have a great deal of responsibility. Fortunately, my responsibility is going to end when I sit down, and yours is going to just begin. What I want to do briefly, and I'm not going to recap everything, I think Mr. Fogleman did an excellent job of detailing what the testimony was and showing you the specific facts that you can concentrate on. But what I want to do is try to boil it down to what really the issue in this case is. And I think it's something that Mr. Stidham is nearly afraid to articulate. Because what their whole premise for their case is that their client lied, and he's a liar, and the police are liars because they won't tell you what happened when he was being interrogated. And as a result, you should throw a confession out the window and find the defendant not guilty. And that's his case. Now, he tries to couch it in different terms and put it in a different form or fashion, but that's what it boils down to. Personally, I find it repugnant with this evidence that Mr. Stidham would make such allegations. It is the first time in my career that I've had to stand up here and deal with a defense attorney claiming that his client lied. It is so incredibly a reversal of roles for the defense, but what else can they do? Their client confesses to his involvement. He tells specific instances of his involvement. He describes details that only a person that is there could possibly know. And I don't care what he says. He can say there's newspaper articles or what else. But you can read in that statement that when he describes the castration of that particular boy, that is a fact that only someone who was there could know. And when he describes that the other two individuals forced them to perform oral sex on them and grabbed them by the ears, those are facts that only a person there would know. When he describes the cutting on the side of one boy's face, those are facts that only a person that was there would know. Unless he successfully convinces you that the police officers got up here and they're the ones that are lying. And they're the ones that are lying to you. And I hope that you have the integrity and the good sense not to buy that, because it doesn't mesh with the facts and evidence in this case, and that's what you make your decision on. The other issue that is involved in this case, I'll address in a minute, but that is going to be whether the defendant was involved enough to be convicted of capital murder. But let me address some of the specifics that Mr. Stidham brought up. Number one, he started off by saying that Mr. Offshay was on trial. Well, for what Mr. Offshay gets paid and for his willingness to go out on a limb and make the statements that he makes based on the flimsy information he possesses, that he was on trial to some extent. It reminds me, in preparation of this case, I listened to a tape recording of Warren Holmes, their other expert. And he said the difference between a $10,000 a year salesman and a $100,000 a year salesman is one's a better liar. And we got a $40,000 a year salesman that came and sat on the bench and talked to you. He says that the reasonable doubt that exists, and this is his first point. I'm going along. We couldn't see his chart, but I'm assuming this is what he was going. The first reasonable doubt is Jessie's story. My client's a liar, therefore you should have a reasonable doubt. That's his first premise. Then he goes and he says, well, the victims, there was no evidence that the victims were sodomized. Well, if you recall the doctor's testimony, was that in all three instances there was anal dilation, that there were abrasions and bruises about the buttocks and the anal rectal area, and then as Mr. Fogleman described, and I know it was hard to follow, but the DNA guy said that there was DNA consistent as coming from a source of male sperm on the pants of one of the boys. But Mr. Stidham says, no evidence. Ladies and gentlemen, you make your decision on the evidence in the case. He talks about the time. And granted, there are inconsistencies in the time. You've heard the experts say, number one, this defendant has a disorder in terms of memory. And number two, all of a sudden, we're sitting here talking about, well, gee, a defendant who's committed 3 murders tells us something that's not true, we must believe that all those other facts that he could only have acquired if he was there must not be true either. And that doesn't make good sense, ladies and gentlemen. All defendants, all criminal defendants, do not immediately tell you the truth. In fact, Mr. Stidham forgets that his very own expert, Mr. Holmes, told you that 99% of the time there will be details that will be inconsistent, will be left out, will be threads that don't connect, and that in 99% of those cases, the defendant's guilty. Mr. Holmes also told you that in situations, I asked him, I said, Mr. Holmes, does it worry you if a defendant recants or says after he confesses all of a sudden says, no, not me, I didn't do it. I lied to the police. And he says that doesn't worry me at all. In 99% of the cases, when that occurs, the defendant is guilty. If there are admissions in that first statement that go to show his guilt, that no one else could know, and I put to you that those are what we have in this case, and that is why this defendant's guilty. Now, he also talked about Jesse's alibis, and I nearly laughed at this, seriously. He said, the state, for him to commit this murder, must think he could be in 2 places at one time. Well, if you listen to his alibi testimony, he was. Because there were people that testified, and you go back and look at your testimony, but he's sitting on the front porch for an hour and a half with somebody, and at the same time, he's with his girlfriend, and they're 2 different people, and then all of a sudden, at the time that the sheriff's deputy's out there, he's with Dennis Carter. And you remember Dennis Carter got up here and testified when he talked to police. First time he gave him a statement, said he hadn't seen Jessie all day. In fact, he said he hadn't been with Jessie all day. Second time he talks to him, he had been with Jessie all day, and this is like a week, 10, 13 days after Jessie's arrest. This is his friend. This is the guy that's in jail that he's concerned about. He wears the yellow ribbon. That close in proximity, he never says a word about being with Jessie that day. Never says a thing about it. One of them was a handwritten statement now. And I don't even think Mr. Offshay would say they coerced that out of him. He wrote it out himself. And yet, he never mentions a thing until he gets up here. And the reason, go back and look and see why these people, and some of them I'm putting to you are just flat liars. Some of them, I think, after months had elapsed, and the Misskellys came and approached them, and they came in with these police reports that said this happened on this day, and they came in with these things that they wanted to help their friend and neighbor, and they wanted to do what they could. And so when they were told, don't you remember this, don't you remember that, they bought into it. But when you listen to it, if they were telling the truth, there would be consistencies. And if they knew where Jessie was on the 5th, they would have told it when they talked to police the first time, not 9 months later. And if they knew where he was, and those that didn't talk to police, they would have reported it. What happened, though, is Fred Revell was the one person who reported it. And he came up with this theory, well, I know where he was, because that's when we paid the money. And he did report it. And he told police, and then they checked it out, said, no, sorry, Fred, you're wrong. It's April 27th. And once that word got out, not another soul bothered to report their alibi information because they didn't want it to get under the scrutiny of the eye of the police department. And I put to you the reason for that is, and the reason why it doesn't jive, their alibis don't jive, the reason why he's in 2 places at the same time is because those alibis are not accurate. And those alibis are not true. Mr. Stidham said gosh, when this incident happened out at Lakeshore, everybody was out there. Well, my recollection of the testimony was that there were 4 or 5 people out there at times. Some of his witnesses put Jessie up there talking to the sheriff's deputy. Now, I guess conceivably you could say, well, with 4 or 5 people out there, Officer Dollarhide may not have seen him. But their witnesses said he's within 5 yards of the car. There's only 3 or 4 people there, and 2 or 3 of their witnesses said he's talking to the officer. Now, maybe you could say, well, gee, these officers run into a lot of people over the course of a day. Runs into a stranger out there, maybe he wouldn't recognize him. Well, these officers all knew Jessie Misskelley Jr. They were all familiar with him, acquainted with him before they went out there. And those officers, all 3 of them, who say Jessie Misskelley Jr. wasn't there. Ladies and gentlemen, when you look at that and compare that with these other alibis that put him in the same place, or 2 different places at the same time, it just doesn't jive and it just doesn't work. He also refers to Jim McNeese. Now, Jim McNeese is the one who puts him with Alan Carter. Jim McNeese is the one who refused to even talk to the police when they wanted to talk to him back in June. Refused to communicate with them, and then gets on the stand and says that night he saw him with Alan Carter. Well, that's fine because he's got him walking down the street with Alan Carter. Mr. Hoggard has him walking down the street by himself. Mr. Hoggard has him up there talking to the sheriff's deputy. Mr. Hoggard has the sheriff's deputy car in Stephanie Dollar's driveway, which the officer testified he never was in her driveway. And when you look at that, if they are accurately recalling based on that event, you would not have those glaring inconsistencies. Because to my knowledge, there was no evidence that any of those people had memory deficits or anything of that nature. And you would expect that information to at least jive more significantly than what it does with the facts you hear from the witness stand. He also refers, and he says, and I don't know if they just missed part of the last testimony or not, but he said part of the reason why the alibi is good is because Jessie Sr. comes home from DWI school and meets the officers driving out of the park, which is rather unusual since he got out of DWI school at 8:45, and the officers left the scene about 10 till 7, which would, again, he's accusing us of putting Jessie 2 places at once. It seems like Jessie Sr. also has that ability because he's in DWI school at 8:45 and he's driving home at 10 till 7. Also, the witness that we put on in rebuttal, and I think it's Mercier. Look at this, please. When everybody got up here testified that at times, whenever they were there, they signed this. And it hadn't got a date on it. But you look and see who's the last name on there. And he told you. And he wasn't friends to anybody. Didn't appear to have any bias. Mr. Stidham didn't attack him in any way of that nature. He just said, I was only there once, and I signed that document then. And that was before the boys were murdered. Now, he says there's no physical evidence linking Jessie Misskelley. And Friday, I think it was last Friday, I'm not even sure what today is, to be perfectly honest. I think it's Wednesday or Thursday. But last Friday, after all the testimony, we put on the guy from the crime lab, Lisa S., and all these people that testified about various physical evidence. And the next morning, I read the paper and it said nothing. It said nothing happened. Nothing was having a brainwashing mind control ability over this defendant. And that they were able just to get him to say what they wanted. And if that's true, then why is this statement perfect? Why are there still some inconsistencies in it? Why would they do that? It doesn't make sense if you believe the defense theory.
the other thing is, too, they want it both ways. They want you to believe that this defendant is so, and they call him handicapped, but he's got such a low IQ that he is practically just like putty in the hands of these police officers. Just, because think of it. No matter what situation you were in, to confess to the horrendous, to running down a boy, an 8-year-old boy, and dragging him back to his death, just think what pressure would be required to cause you to do that. Just think of that. And what they're telling you is that this person, because he has such a low IQ, was persuaded and coerced into doing it, yet the way he was able to give a statement that on the tape that you heard that had such good facts is because although he's so slow, he's easily suggestible, he's also so smart, he can pick up all this stuff while they're questioning and then spit it back out to you in a statement. So it's really, he's slow for one purpose, but he's very intelligent for another purpose. And they can't have it both ways because it doesn't make sense. And if it doesn't make sense, then it shows that this defendant is guilty. The second issue is, and I think it's one that's crossed your mind from the time you heard the confession, is if the law requires the state to prove that this defendant acted with premeditation and deliberation with the purpose of causing the death, him or an accomplice, even under the tape, how do we find that this defendant committed capital murder? Because what he says indicates that his involvement is relatively slight. Well, examine what his statement says. He ran the Moore boy down and brought him back. At the time he did that, Damien was already beating up one of the boys. And he brings him back. Now, he'll say somewhere in that statement, he'll say, well, that's when I saw what was happening, I left. But that's not true. It can't be. Because in his statement, he then proceeds to detail how the boy was cut in the face. He details how the boy was castrated. And he doesn't just say he castrated him. When they say, are you sure? He said, yes. And they said, well, how'd they do it? And he said, they got him down on his back. They were both on top of him. One of them was sitting on him. And then I saw the blood. Now, if his involvement was that he ran and chased the boy down and brought him back and then he took off, how was it he saw all of those things? How was it that 3 weapons were used to inflict these injuries if there's only 2 people that are left there? And in talking about his involvement, an accomplice, he's guilty as an accomplice if he aids or agrees to aid in the participation of the offense, or aids or agrees another in the commission of the offense. It's with the purpose, and when you get back there and read the instructions, purpose is defined as consciously engaging in conduct of a certain nature. If he consciously engaged in conduct that involved him in this act, then he's guilty of capital murder if that's the result. See this picture? This is the Moore boy. This defendant, he won't look up, he won't look at you, but this defendant's actions, and you just think about it. If this defendant does not chase down Michael Moore, if he does not run through the woods and chase him down and bring him back, Michael Moore lived. Michael Moore gets to go home at night, his parents get to be with him. But because of this defendant's actions, because of what Jessie Misskelley Jr. did and what he told you about in that tape statement, Michael Moore doesn't go home anymore. And because if he hadn't chased him down,
if Michael Moore gets away? It's only a few hundred yards to the truck stop. And certainly Michael Moore is going to report what's happening. And if Michael Moore gets away, maybe the others decide that this isn't a good thing to engage in and they get out. Maybe it's just a kidnapping and a battery. Maybe they're just seriously hurt. But ladies and gentlemen, we'll never know. Because Jessie Misskelley Jr. didn't let Michael Moore get away. He chased him down like an animal and brought him back. And as a result of his action, Michael Moore's dead, Stevie Branch is dead, Chris Byers is dead. And there's no getting around it. And you can cut it any way you want to. You can sit there and look over it. But when you read that tape, or listen to that tape, and look and go over this evidence, the actions of this defendant certainly meet the acts of an accomplice in aiding or agreeing to aid or assisting in the commission of a capital murder. And for goodness sakes, in a case like this, I know there's a lot of pressure, there's a lot of attention on it, and it's a great responsibility to go back there because the person you've looked at for 2 weeks looks young, and it's easy to empathize and sympathize with them. But please, for goodness sakes, go back there, follow the law. And when I asked you in opening or in voir dire about using your common sense, what I meant was, in this case, you are presented with a confession. A confession that gives details that only this defendant could know. And if under any other circumstances, you would probably say it would be ludicrous not to say, well, gosh, I mean, the reaction is, well, the person confesses and they know the details, then they're guilty. But the defense, through bringing in so-called experts such as Mr. Offshay, have tried through smoke and mirrors to make it sound like a person that confesses to such a heinous crime and admits their involvement and gives you specific details of the involvement, that's indicative of someone who was forced or coerced to confess. I think when you go back and you apply your common sense and you do what's right and you think about the evidence in this case, you're going to know that what the evidence shows is that this defendant ran down Michael Moore, that this defendant was there, he was involved, and he's guilty of 3 counts of capital murder. You will have a verdict form that will be given to you, and you'll take back all these instructions. And that verdict form will say, we, the jury, find the defendant, Jessie Misskelley, guilty of capital murder, count 1, involving Michael Moore, count 2, Stevie Branch, and count 3, Chris Byers. And the judge will tell you there's some lesser included offenses that he mentioned. It's not like you take all these options and spread them out on the table and say, well, gee, this looks like a good one. You start at the top. You start with capital murder. And if this defendant, if from the evidence you find beyond a reasonable doubt that the defendant's guilty of capital murder in each of those counts, you check those boxes and the lesser included offenses are not even to be considered. And I trust that when you go back there, you'll carry this heavy responsibility, but you'll do what the law and the facts require, and that's return a verdict of guilty. Thank you very much.
Well, the only way I could let them go home would be if you all agreed on it, because I mean, well, would you all agree that they could then come?
I agree. My opinion is keep all this charge.
The prosecutor made reference to the defendant's silence.
We'll put a record. We'll make a record. Just wait.
They did what?
He commented to the defendant's silence and refusal to look at the jurors. That's the same thing.
We'll make a record. We'll make a record. Anyway, Your Honor, I have no problem. What I would suggest for her benefit is that she not be discharged, but she be allowed to return home.
Both of them.
Both of them, and just not
Well, I
watch
could
TV
give them
or
the
just not
customary.
watch-
I could give them the customary cautionary instruction and let them go.
That's
Well,
my
I'm gonna
opinion.
keep them here for a while and then do that. I think that probably, if I give them the ordinary cautionary instruction that they're still jurors and that they're not going to discuss it, then that might work. But I'm not. I can't. I'm not going to dismiss them.
That's fine.
Okay. Yeah, I sure do. That needs to go to the jury. Where are my jury instructions?
They're right here.
That all needs to go with them right now. And then as soon as Barbara goes through all of that evidence that we're going to send back there, then one of y'all takes it back. And I need somebody, chief or sheriff's department, stationed out in the hallway, just haul up a chair and keep everybody out of there. I'll let the lawyers go back and forth. Okay, well, while they're back there, then if we want to go back there. Okay, the next thing about sending out for food. Yeah, he talked like let's go up there and get catfish or steak or something like that for $4 or $5 a piece. I think when you take that back there, tell them that the judge make a list of what they wanted. They could have a catfish dinner, they could have a plate lunch, or they could have a small steak. And just write down what we need. And ask the two alternates too. But don't stay in there. Just let them write the list. I'm planning on being here. I don't know. I mean, it simply really depends upon the jury. I'm willing to stay very late if necessary, but before we stay past midnight, I'd probably consult with them to see if they'd benefit by going home, getting a good night's sleep, and coming back. So I'm going to kind of play it by ear. It's just 4:25, so I mean, there's ample time for them to arrive at least the first verdict or maybe a final verdict. No, they won't be sequestered. I'm not going to do that. They hadn't been till now. There's any point in doing it now. They're going to be sequestered back there in that hall. Yeah, I don't know why not. I guess so.
You're gonna have to prove here anyway.
Yeah.
Dan Lynch.
Yeah, where is Dan? Outside?
Judge, we spoke earlier about being able to play another camera right now. Can we do that now at this time that the jury is back? We need to make a record. A couple of things.
I gotta get one more.
Theoretically, if I treat all three cases equally separate, it would be a nightmare.
Yeah, I'll tell you that.
Let's go.
Hi, Gary. 2020 They don't have to go necessarily in that order. What are you going to see?
This is second page. I believe they got the first page.
If you don't want to put it in yours, I'll put it in mine.
But this is the second page, which is the same sound. The original is small. Just for their simplicity's sake.
What does this stuff make?
Is this everything?
Oh, okay.
Yeah, they're not gonna send us that back. If they want this clothing and shoes and all that, they can ask for it.
Well, it's sort of like something's been lifted off my body and it's laying on me for about there ain't room, man. Where do y'all put these shoes? What are we supposed to shoot from this thing? We just put it on heavy and then what can we put it on?
Have a good service. We've only moved about 3 years. I've been shooting at 2 rooms. Can we please decide that on the I'm just trying to work together.
I know if I can make it a copy of the
Yeah, no, look, yeah.
knock it
We'll have to ask the
That's just what you need.
Don't forget we owe this man some money.
Yeah.
One transcript. Okay, I think what's gonna get us, I guess we're gonna,
Yeah, they do have one transcript.
Okay, they were wanting the negative statement. They said the folder was set, they wanted to ask
to be tired of it.
They want to know about the transcripts and tapes.
Well, I mean, I don't mind giving them to them if y'all don't have any objection to it.
I don't see that.
Huh?
I don't think we would have they all had a copy the other day.
Yeah, and that's permissible. One of the first cases was a case where I tried a long time ago.
Your Honor, we do need to make a record.
Yeah, I know what you're going to do. We're going to do it.
Also,
No.
Also, these mics out.
No, they're probably on, so don't say anything you don't want to hurt.
What they want is they all want a copy.
Well, I don't mind, and they don't have any objection to it. But Brent well, tell them that we'll have to find where the extra copies are, and we'll bring them to them.
Okay, that's all they was asking for.
Okay.
No, something else has come up that everybody was sitting around talking a while ago.
Yeah, about
those two were sitting there.
Well, I mean, about all I can do is excuse them.
I don't think it'll be a problem anyway. But
I don't either.
at this point, I don't want to waive anything, but let's see what happens there.
Tell you what, John made a super good closing argument, one of the best organized. It was lengthy, but it didn't. You didn't feel the time because it was so well organized. He wasn't repeating himself.
I thought.
Usually when you talk longer than 20 minutes or 30 minutes, you start repeating yourself, but he didn't.
John did a damn good job. Unfortunately,
well, I thought Brent did a good job. You did too, Dan. I thought you had it organized good on your chart.
Thank you, Your Honor.
Yeah. I think what I'm going to do with these ladies is give them the admonition not to discuss the case and then let them go home. But now they may want to stay, though. I don't know.
I think they're going to have to leave very much because of all the conversations that are happening. And
yeah.
Is there maybe an office we can put them in?
Yeah, they can go back to the county judge's office. Yeah, we're good. Would y'all like to go back to the county judge's office back there? Because we might need to do some talking in here that wouldn't be appropriate for you to hear. The second thing is, yeah, you're going to have to go out the front door, too. If that door's not open, I got the key in my pocket. But we're going to feed you. Did you give your order, or the sheriff said he had that taken care of? I think I might give you that admonition we usually give about not talking to the case and then let you go home. Because we've all, if you want to, of course you can stay around here, but if you stay around here, we don't want you inadvertently hear any conversation that the lawyers might be having. No, it's fine to stay. Oh, I wouldn't stay past midnight.
I mean, is there a point where you can go in there and say, why don't y'all just give it a rest?
Yeah. If they're unable to agree on anything, yeah, and that's likely to be midnight. Because you see, if they are able to agree on anything, we're going to have to come back anyway. So we'll be here tomorrow, I'm sure. If they come back in the next 30 minutes or so, I'll probably recess until tomorrow anyway, because they get to put on extra proof. They get to, and I got to read another 10 or 15 minutes worth of instructions. So,
What are we talking about?
I mean, they were asking, what the time schedule was, and I'm saying if they came back in the next 20 minutes or an hour, I'd probably still recess till tomorrow.
Right.
Yeah, if y'all don't mind. I think they're ordering catfish or something like that from the line, so I'm gonna feed y'all for sure.
I'd like to make a bid on the bicycle.
You might do all right. One of them didn't look too bad. I think
honor of Clay County putting up with this amount on the courtroom wall.
I thought they made some good closing arguments. Yeah.
Overall?
Yeah.
Overall?
Yeah.
I don't think it'd be too tough.
You know?
Maybe pretty quick.
Y'all leaving, or what? Do you got one of them broken down over there? Huh? I want to go out there and look at the setup in just a few minutes, because now I got some time. As soon as we got a little bit of stuff to do here first. All right, gentlemen, Brent, y'all ready to? They wanted to make a record.
Yes, Your Honor.
A record.
Yes, Your Honor.
A record.
Yes.
All right. Let the record reflect that this is a hearing out of the presence of the jury and after the jury has proceeded to deliberation.
Your Honor, we would move for a mistrial on the following basis. First, during the summation of Mr. Davis, we believe he made a veiled comment on Mr. Misskelley's failure to testify. He talked about him sitting there with his head bent over, in different clothes, different haircut, and won't look you in the eye. We felt that was I don't have that quote, but the record will reflect exactly what all they said. And, I feel that was a veiled reference to this.
Your Honor, not to comment that the defendant didn't testify.
You want to respond?
Judge, I can't recall exactly what I said, but it certainly wasn't intended to be a comment on his not testifying. It was a comment on the fact that his appearance here in the courtroom had been that of a meek, mild juvenile or pre-juvenile, contrary to what his picture showed and contrary to what his actions indicated in the tape. And I don't think I made any comment whatsoever on his failure to take the stand.
No, in fact, you used the term veil, Mr. Stidham. The court was conscious and aware of the comment made and did not feel at the time that it was an inappropriate remark that would single out or call to the attention of the jury the defendant's failure to testify. It just simply was too remote to do that, in my opinion, and a mistrial after several days of trial would be a drastic remedy, and that if there was any error in that, it was so minuscule that it was harmless. And I frankly didn't feel that from my observation of the closing argument, the tactic that it was employed was a proper inference that the jury could draw from the appearance of the defendant from the photographs that were introduced and his appearance during the trial, and if anything reflected his demeanor during the trial and not his failure to testify in his own behalf and recant or deny any statement he made. So the motion for mistrial will be denied, and the record's made on that issue.
Thank you, Your Honor.
Thank you for your consideration, Your Honor.
I have a couple other ones, Your Honor, just real briefly. Also asked for a mistrial on the ground of the prosecution's remarks. During closing, he talked about 99% of cases when people confess they're guilty. I objected during the trial when that response was solicited from Mr. Holmes, while was our witness. We certainly didn't ask that question, Your Honor, and objected. I thought that was using other people's guilt or innocence to reflect on the guilt or innocence of Mr. Misskelley, and that has now been compounded by the prosecutor's comment during closing. I feel that at this point we're entitled to a mistrial.
Well, for several reasons, I'll deny the motion for a mistrial. One, and perhaps the most important reason for denying it, is no objection was made at the time. The court was not given an opportunity, therefore, to rule upon any objectionable comment, nor was the court given an opportunity to caution the jury on excessive language that any attorney might use other than the standard instruction that's given in 101. So your failure to object at the time, in my estimation, is a waiver of that objection. Secondly, it seems to me to be fair comment based upon the evidence and testimony and the nature of the defense. Inasmuch as the defense called so-called experts or experts in the field of interrogation and suggested to the jury that the statement was contrived, manipulated, coerced, and otherwise involuntary, that it was an appropriate line of inquiry, and that the very nature of the defense invoked those inquiries and made that a pertinent subject matter of inquiry. And that'd be my second reason for it.
Thank you, Your Honor.
All right.
Judge, would you like to send out? I've got the jurist. This I call and get through.
Okay, for gentlemen, I'm going to order for the lawyers involved, the court reporter, and the court, the officers that have to be here. So put down what you want on this list.
Sign your name to it.
Lobster available. Lobster available. Where do you go?
We're going on the state line here.
What they have, so I'll just,
Oh, this is the menu.
Well, that's the stuff, menu. You get a lot of other things.
Oh, I see.
besides
Okay.
that. They have nearly anything you want. Their ribs are real good. Their catfish plates are excellent. You can get whatever. This was just, I ate lunch for a day. Their smothered steak was delicious.
Did you give Barbara one?
You can get fries and baked potatoes.
Whatever comes with it. Fries?
Standard plate.
Yeah. I can't order for the media. The county would go broke if I.
I do already have the jurors.
Well, you're men too now, and two ladies that are alternates. They're over in the judge's office. Did you order something, Pete?
No. What'd you order?
I ordered the roast beef with corn and mashed potatoes.
Are you a circlet, Sheriff? Is that?
You can order for your office help too.
Oh, what do you want? What do you want to eat?
John, if y'all want to order for your people that are here too, the sheriff's giving it out. Just
I might just have him get. I don't really want to.
well, just write on the back of Brent's what you want. If you want to, huh?
John? The two alternate jurors were sitting over in the box.
I sent them to the county judge's office, and I had the sheriff go ask them what they want to eat.
I think John and I are pretty much in agreement that it might be best, considering the fact that they may have heard Mercier remark about Jessie being murdered and those son of a bitch, that it might just be best to send them out of here.
Well, I mean, that's not exactly what I said. I think that's fair interpretation. But what I
wouldn't
said,
force you to. I suggested that.
What I said was that I thought it wouldn't be a bad idea for the court to inquire if they've heard any comments while in the courtroom.
I just asked them that a while ago, and then they indicated that they didn't hear anything. They asked me, was I suggesting that they might ought to go home so they wouldn't hear anything, and I told them no, that they could stay. I think they want to stay for a while because they're curious.
It's the only way we can leave is go out there.
Okay, that's it.
Darwin, I got 5.
They were asking about copies of the transcripts.
Yeah, if y'all have got them, they agreed we could send them back there.
I'm afraid they may just call them out.
Well, I told them we'd send them back there, so see if you can find them.
I'm not going to have 12.
Just get the ones you got.
Dickie called me last night. They're having permit hunts up on this Harold Alexander Wildlife Management area. Had never turkey hunted on it in 10 years.
And Elvis called in and said they're giving out 50 permits a week, and it's like, I don't know, thousands and thousands of acres. And so we're submitting permits for the second weekend up there, and there's going to be
There ought to be a lot of turkey there. What you got?
Just one of the jurors passed this note to me.
No, what Brent said said something. I did laugh at that, but what Brent said was that the guy took the bench up here, and then I laughed about that instead of the witness stand.
That was I think it was maybe like
Jessie passed that to me.
What was he? He got agitated, didn't he?
That's why I didn't put him on the stand.
What was he getting mad about?
Brent was calling him a murderer in his closing. That's why I couldn't put him on the stand, Judge. He would have just exploded. Couldn't do it.
Understatement of the year.
So,
y'all were having trouble with him, weren't you?
Yeah, I thought he was fixing to just
going to get exploded. Stand up and
He was mumbling something audibly.
I'll do my best to keep him under control.
Listen to this.
No, that's Barbara's there. This one's supposed to be off.
I'll pressure left me in my thing. I got so pissed off a little. I couldn't be quiet, He keeps moving. I got so pissed off with him. I hope we win, but I don't give a shit anymore.
As long as y'all don't have to do the appeal with that outfit and
I think you're doing crap. I think we'll have to do it.
Well, they're getting paid big money to do nothing, as I see. And how many people they have on that staff?
I don't know.
What you ought to do is request that they do the appeal.
If it did get remanded. If it did get remanded.
Right now, I don't see a whole lot of potential error in the case.
The only thing I think I can hang my hat on it all, and if the judge will find some way to get around it, is our Rule 2.3 argument we raised in our expression about they didn't tell him it was free to go when we got him down there.
Oh, you mean when they put him in the police car?
Well, yeah, when they took him down to the station for the first question. So there was a case of Little Rock I cited in my brief.
Yeah, I remember that, but now he volunteered to go.
Well, the case out of Little Rock, the guys, that's what they did. They quote this black guy and say, "You want to go to the station with us?" And he said, "I ain't got no problem with that." That's a quote in the opinion. Then when he's down, an officer says, "You're here voluntarily." But the officer never said, "You're free to go." In the court, now the court affirmed his conviction. They said they had grounds to. He could say there was enough evidence to arrest him at that point. At the time they first picked him up, and so they didn't. So he didn't have to be told.
Of course, we maintain that he was asked to come up as a suspect only, and I think that's true. I really do.
I didn't at first, but I do now. Well, actually, I was the first one that said that. I kept telling Dan and our experts, I said, "Damn it! When they got him up there, he wasn't a suspect. He wasn't."
That little boy that gave that whispering statement. That's why they called him up here, because that little boy said that he knew something about it. That's what I believe.
Well, the little boy.
Have y'all heard the little boy's statement? Is he not credible at all, or what?
He says there's 5 of them there.
Hell, there might have been.
Well, it doesn't matter. The little boy first started talking early in May.
Okay, well, count out 12 of them there and make sure they don't have any markings on it, and then let's check them before we send them back. I've never seen that.
The little boy started talking in May, early May. He kept saying that he was making veil references and he was there. He never would admit he was there, but he kept acting like he knew something. Jessie was his babysitter. Jessie spent the night with him the night before he was arrested.
Yeah, I know.
He kept saying there's 5 people there. Finally, he starts saying, I think he finally does, like right before Jessie's arrested, said, I got May at the time frame, which was wrong, but he says there's 5 men. He keeps saying there's 5 people. Always saying there's 5 people. And he keeps, first he's telling the story, and I was out there another time when some 5 men were out there doing stuff, and he started saying, he said, I don't know any of them. I did see one of them flash mark at one time, but I don't know who he was. He keeps saying, I don't know any of them. The day Jesse's arrested, the next day he comes to make a statement that it was Jessie, Jason, Damien, and 2 other guys who I don't know. Now he's saying Jessie, Jason, Damien, and Robert Myers, and another guy he doesn't know.
Yeah, I'd heard that they indicated that, yeah.
But he didn't start saying, putting any names, and he certainly knew Jesse. That's why this is what the state's going to do in the next case. They don't have anything. They get right to verdict. In the next case, they didn't have.
They're going to use him.
They'll use him in the next case. Yeah. They really couldn't use him in ours because he didn't match up what Jesse was saying either. But they don't have that to worry about next because Jesse won't be tested.
Well, my whole theory, it doesn't really fit with what I was thinking. I was thinking that the reason Jesse broke down and started telling him what he knew was because he heard the little boy's voice, knew who he was, and that perhaps he had told the little boy what happened. And that's exactly what I thought.
That's always possible.
Hell, I would have argued that. I would have put that in my argument. That the reason he broke down wasn't anything historical, and it wasn't anything that he knew his goose was cooked because he spent the night with the boy the night before and he told him what happened.
It's a good argument. Don't tell the prosecutor in case you try it again.
I mean, it's just a natural. If it was receiving evidence.
If it wasn't, I don't think it was it?
I don't know. Barbara, did we take the autopsy protocol in? Was it received?
Was the evidence, was the autopsy itself in evidence?
It wasn't received in evidence.
Just tell them the report wasn't offered into evidence.
Brent tells me you're Lamb to Kai.
Yeah, sure am, yeah. Well, Brent is.
Yeah, I know Brent is. Did he tell me your son is president? Well, is he president?
Oh, no. He's just a member. He's just a member. In fact, Jonathan, I don't think, can be an officer because he's on an academic scholarship and he gets room and board, so he can't live in the house. And they got some kind of rule that if you live out of the house, you can't serve as an officer. And he's real unhappy about it because he'd like to be president, but no. Yeah.
I'm sorry.
Yeah, I was an officer.
Oh, you were?
Yeah.
Maybe that's why.
Yeah. No, I wasn't president. I was vice president. I was a pledge trainer and ritualist. That was the one that was most fun.
What is the ritual? Party chairman?
No,